Okay.
Good morning. My name is Robert Shea. I am the presiding officer in this matter, South Coast Wind, EFSB 22-04 and DPU matters 22-67 and 22-68. This is the 5th day of evidentiary hearings. This is the 27th of July. Let me start off by introducing the other siting board staff members who are here with us today. For the record, this is a video conference. We are doing this by Zoom. We have Andrew Green, who is the director of the siting board. We have Joan Foster Evans, the general counsel of the siting board. Wayne Wong, who is the assistant director of the siting board, and Smitha Devakar, who is an analyst with the siting board. I'll ask counsel to introduce themselves now.
Good morning. My name is Eric Runge, counsel for the company with Dave Pitney, and address is in Boston.
Thank you.
Good morning. This is George Pucci from KP Law in Boston. I represent the intervener town of Somerset. With me today is Nicole Montana. She's assisting me on the case. She is not listed as co-counsel of record because she is a Northeastern Law co-op student. So I just wanted to specify she will not be, saying anything on the record, but she's here assisting me today.
Thank you.
Mr. Shea,
Yes.
I meant to mention that Sophia Browning is on the Zoom as well. She is a colleague of mine with Dave Pitney.
Thank you. Thank you. Why don't I start off, Mr. Runge? You have a number of witnesses here. We're not going to get to them right away, but I'll ask you to introduce who's present.
Sure, happy to do that. Today we have all returning witnesses, so they've all been sworn. We have Kelly Smith, Mr. Dan Hubbard, Kathleen Freeman, Kelsey Perry, Tim Ryer, Jennifer Flood, and Vic Mastone.
Thank you very much. Mr. Pucci, would you please introduce the witnesses, after which I'll have them I'll swear them.
Yes, today I have all the Somerset witnesses who submitted pre-filed testimony on behalf of the town. And those consist of Nicole McDonald, Patrick McDonald, Nancy Thomas, Kathleen Sousa, Peter Peltier. They're all in the same room. Tim Turner as well is also in the same room in Somerset. And we also have Mr. Paul Healy participating from his own location.
So that was, I'm sorry, it was Nicole McDonald and Patrick McDonald and
Correct.
Kathleen Sousa.
Yes.
And what was Mr. Pelletier's first name?
Peter.
Peter, okay. Tim Turner and Paul Healy.
And did you get Nancy Thomas?
I've got Nancy Thomas on there also, yes.
Perfect. Thank you.
All right. For all of the witnesses, so for all the witnesses for the town, Mr. McDonald, Ms. McDonald, Ms. Thomas, Ms. Sousa, Mr. Pelletier, Mr. Turner, Mr. Healy, I'll ask you all to raise your right hand. Please raise your right hand. I'm going to administer the oath. Do you swear that the testimony that you will give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay, let the record reflect that the witnesses for the town have been sworn. All the witnesses that are here on behalf of the company have previously been sworn and they're still under oath. So let me ask Mr. Pucci, do you have direct examination for your witnesses?
I do.
Thank you. Please go ahead.
Okay, we'll proceed with Nicole McDonald first. Good morning, Ms. McDonald. Can you hear me?
Good morning, Attorney Pucci. Yes, I can.
Please state your name and address.
Nicole McDonald, 30 Admirals Way, Somerset, Mass. 02725.
Are you a member of any town board or committee?
Yes,
And what is that?
the Somerset Planning Board.
Are you testifying in these proceedings on behalf of the town of Somerset?
I'm testifying on behalf of the town of Somerset as a resident, not in my official capacity as a planning board member.
Are you the same Nicole McDonald who sponsored pre-filed testimony and information request responses in these proceedings?
I am.
Are you able to answer questions today on any of the topics raised in either your pre-filed testimony or the responses to information requests which you provided?
I am.
Were the responses to the information requests and your pre-filed testimony that bear your name prepared by you or under your supervision with the assistance of counsel?
Yes.
Do you have any changes to offer for the record at this time to any materials that were submitted under your name?
No.
Do you adopt all of the materials as your testimony and responses to information requests in these proceedings?
Yes.
Thank you. Now I'd like to go to Mr. Turner. Good morning, Mr.
Good morning.
Mr. Turner. Please state your name, business affiliation, and address.
My name is Tim Turner. I am the Health and Conservation Agent for the town of Somerset. The work address is 140 Wood Street in Somerset, Massachusetts, 02726. I am also a Somerset resident.
Are you testifying on behalf of the town of Somerset in this matter?
Yes, I am.
Are you the same Tim Turner who sponsored pre-filed testimony and information requests responses in these proceedings?
Yes, I am.
Have there been any changes to the testimony or the information request responses since they were submitted?
No.
Was your resume submitted as an attachment to the witness list filed by the town of Somerset?
Yes.
Have there been any changes to the resume since its submission?
No.
Were the responses to information requests and the pre-filed testimony that were submitted in this proceeding that bear your name prepared by you or under your review and approval with the assistance of counsel based on personal knowledge or information and documents available to you?
Yes.
Do you have any changes to offer to any of the materials that were submitted under your name?
No.
Do you adopt all of those materials as your testimony and responses in this proceeding?
I do.
Thank you. I'd like to go to Mr. McDonald.
Yes, good morning.
Good morning.
Patrick McDonald for the record.
Yes, and your address, Mr. McDonald?
My address is 30 Admirals Way, Somerset, Massachusetts, 02725.
Are you related to Nicole McDonald?
Yes, she's my wife and my law partner.
I'm not going to comment on that. I'm going to continue with my questions. Are you testifying on behalf of the town of Somerset in this proceeding?
Yes, I'm testifying as a resident of the town of Somerset.
Are you the same Patrick McDonald who sponsored pre-filed testimony in this proceeding?
I am.
Can you, are you able to answer questions today on any of the topics addressed in your pre-filed testimony?
I am.
Was the pre-filed testimony filed in this proceeding on your behalf prepared by you or with the assistance of counsel based on personal knowledge and information available to you?
Yes, it was.
Do you have any changes to offer for the record at this time to any of the materials that were submitted under your name?
No, I don't.
Do you adopt all of those materials as your testimony in this proceeding?
I do.
Thank you. I'd like to go to Ms. Sousa.
Yes.
Good morning.
Morning, how are you?
I'm well, thank you. Please state your name and address.
Kathleen Souza, 130 Pocasset Street, Somerset, Mass.
Are you testifying on behalf of the town of Somerset in this proceeding?
I am.
Are you the same Kathleen Sousa who sponsored pre-filed testimony in this proceeding?
I am.
Are you able to answer questions on any of the topics raised in your pre-filed testimony today?
Yes, I am.
Was your pre-filed testimony prepared by you with the assistance of counsel based on personal knowledge or information available to you?
Yes,
Do you have any changes to the testimony that was submitted under your name?
I do not.
Do you adopt all of those materials as your testimony in this proceeding?
I do.
Thank you. Could we go to Ms. Thomas?
Good morning.
Good morning. Please state your name and address.
Nancy Thomas, 71 Ripley Street in Somerset, Mass.
Are you testifying on behalf of the town of Somerset in this proceeding?
I am.
Are you the same Nancy Thomas who sponsored pre-filed testimony?
I am.
Are you able to answer questions today on any of the topics raised in your pre-filed testimony?
Yes, I am.
Was your pre-filed testimony prepared by you with the assistance of counsel based on your personal knowledge or information available to you?
Yes, it was.
Do you have any changes to the testimony that was submitted under your name?
I do not.
Do you adopt all of those materials as your testimony in these proceedings?
I do.
Thank you.
Thank
Mr. You're welcome. Mr. Peltier,
Yes,
good morning.
good morning.
Please state your name and address.
Peter Pelletier, 13 Stoddard Street, Somerset, Mass. 02725.
Are you testifying on behalf of the town of Somerset in this matter?
I am.
Are you the same Peter Peltier who sponsored pre-filed testimony in this proceeding?
Yes,
Are you able to answer questions today on any of the topics raised in your pre-filed testimony?
yes,
Was your pre-filed testimony prepared by you with the assistance of counsel based on personal knowledge or information available to you?
yes,
Do you have any changes to the testimony that was submitted under your name?
no,
Do you adopt all of those materials as your testimony in this proceeding?
I do.
Thank you. Dr. Healy,
Good morning.
good morning. Could you please state your name, business affiliation and address?
Good morning. It's Paul Healy, 76 Gay Street, Somerset, Massachusetts. And I was employed for many years with the Public Health Service, specializing in occupational environmental medicine. I'm now retired and a resident of Somerset, living in the Brayton Point neighborhood at 76 Gay Street.
Thank you, sir. Are you testifying on behalf of the town of Somerset in this proceeding?
Yes, I am.
Are you the same Paul Healy who sponsored pre-filed testimony in this proceeding?
Yes.
Are you able to answer questions on all topics addressed in your pre-filed testimony today?
Yes.
Did you submit a resume in connection with your pre-filed testimony?
Yes, I did.
Was it submitted by the town as an attachment list to the witnesses listed by the town?
Yes.
Have there been any changes since its submission?
No.
Do you have any changes to offer for the record with regard to any of your pre-filed testimony?
No.
And do you adopt your testimony as your testimony in this proceeding?
Yes.
Thank you, sir. Mr. Presiding Officer, I'm completed with my direct examination and have the panel of witnesses available.
Thank you, Mr. Pucci. First, I'll go to Mr. Runge. Would you like to start with questions on the witnesses?
I would, thank you.
Thank you.
All right, so I think I'd like to start with Paul Healy. And Mr. Healy, just so I'm clear, should I call you Dr. Healy or Mr. Healy?
Paul is fine.
Paul?
Yes.
Okay, Paul. Well, it is good to finally see you. We've seen your name up on the Zoom screen, but we haven't actually seen you until now. So welcome to our get together here. Have you been listening to all of the hearings so far?
About 99% of it. Yes.
Okay, excellent. So I looked at your CV, your curriculum vitae, and it's impressive with all those degrees. I'm wondering, how do you use all that education nowadays?
Taking care of my wife.
Okay, so are you employed at all?
No, I'm not.
Thank you. Did you say that you were a former town official of some sort? Could you tell me that?
I'm on the Council on Aging board, and I'm also starting on the Historical Commission board as well.
Okay, thank you. So are you speaking, as we heard, I think earlier, just confirm that you're speaking on behalf of the town today, is that right?
Correct.
And did the town ask you to be a witness?
Yes,
You didn't ask the town, you didn't volunteer, they sought you out, is that correct?
well, I think I've shared a lot of information with the town and town leadership. I think the answer can be yes to both of those.
Mr. Presiding Officer, this is Attorney Pucci.
Yes, sir.
I don't have an objection to any of this line of questioning, but I just want to note for my witnesses, because they're not sitting in the same room with me, that they should not reveal or I'm going to object to them revealing the substance of any communications that they had with me. And I should just specify, all of the witnesses that are testifying in this proceeding, at my request, I had numerous conversations and written communications with them. I consider those to be privileged, both under the attorney-client privilege and work product doctrine. So I just want to caution my witnesses in advance that they can answer Mr. Runge's questions as to, how they're involved in this proceeding, but they should not reveal the substance of any communications that they had with me.
Mr. Runge?
I would just say, while I am somewhat dubious about the attorney-client relationship here, I'm not intending to get into any questions about their conversations with Mr. Pucci.
Okay, and what about Mr. Pucci with respect to conversations with each other and town members, town officials? You don't consider those areas to be privileged, do you?
Correct, I do not. There were no communications that were held in executive session, under the open meeting law. So yes, any type of communications amongst the witnesses or with the town, those are all fair game. They can freely inquire and answer on those. I just wanted to caution my witnesses as to communications with me. They can identify if they spoke to me or when, but just not the substance of the communications.
Very well, thank you. Go ahead, Mr. Runge.
Just one moment, please. Just a second. Thank you. All set.
Okay, thank you. All right, I think I was asking whether the town asked you to be a witness or whether you stepped up and volunteered. And I think you said that the town asked you to be a witness, correct?
Yes, but let me just clarify a little bit further. So I have for past several months been writing to the town on the subject of the Brayton Point projects. So as a result of that, they asked if I would participate in this process.
Okay, and you just mentioned projects, plural. So can you tell me what projects you mean?
So specifically with Prismium and SouthCoast Wind.
Have you had interactions with Prismian?
I've attended meetings with them, and we've talked at those meetings, yes.
Have you had interactions with representatives of SouthCoast Wind?
I have.
Can you identify any particular people that you've spoken with?
Yes, Ms. Smith, Ms. Perry.
Anybody else?
Not that I can recall specifically, no.
Did the town tell you what your scope of authority was to speak on the town's behalf?
I'm here as a private citizen, a resident of the town.
Okay. And that's it, correct?
That's correct.
All right.
Mr. Shea,
Yes.
Attorney Pucci again. I want to reiterate what I said at the beginning of the proceeding is all of these witnesses are testifying on behalf of the town. Their testimony is binding on the town. To the extent that I don't know what the point of the questioning is, that they don't speak on behalf of the town. They are town witnesses, and they're testifying on behalf of the town of Somerset.
And so that's the basis for your attorney-client privilege assertion.
Correct.
Okay, I understand that. Thank you.
Excellent. Though I noticed, again, you were listening to much of the hearing. Did you hear on the first day that the town's attorney, Mr. Pucci here, stated that none of the resident witnesses, including you, were speaking as expert witnesses for the town?
That's correct.
Right, so you're confirming the accuracy of that statement. Thank you. Mr. Healy, you're not a neighbor of the Brayton Point site, are you?
No, it's just a broad area of Somerset, essentially, is what I'm trying to say in that statement.
Well, I'm just trying to get clear that you're not an abutter of the Brayton Point site where the project will be located, are you?
No, I'm about 3 miles from that area.
Isn't your address actually more like 4.5 miles away from the company's project?
You may have taken the distance. I have not.
I just did a Google search. It came up that it seems like you're quite a distance from the project site itself. So you're not a neighbor of the project and you're not an expert witness for the town, correct?
Correct.
But it seems like you have submitted about 30 pages of direct testimony. It seems to be largely a technical environmental critique, including of the company's draft environmental impact report. Would you say that's a fair characterization of what is in your testimony?
I do.
Is that testimony what the town asked for from you?
No, I had done that previously before this proceeding, before I was asked to participate in this proceeding.
Did the town pay you to produce your testimony?
No,
Mr. Healy, did you seek to intervene in this proceeding?
I did not go through that process of, I believe, the intervening process.
Did you seek limited participant status in this proceeding?
I don't know if I can technically answer that question. I'd ask Mr. Pucci. Again, he just asked if I would participate in this process.
You have a law degree, correct?
I did. I went to law school. I never sat for the bar.
Well, you could have put together a petition to intervene or a request for limited participant status relatively easily, correct?
It's been 20 some years since I went to law school. I would argue no. Could I figure it out? I guess I could.
I bet you could. Do you know what the standard is for intervention in a siting board proceeding?
No.
All right, well, it's that a person be substantially and specifically affected by the proceeding in some way. Are you substantially or specifically affected by this proceeding?
Not to,
By the project?
Mr. Shea?
Yes.
I object. I know we have wide range in these proceedings, but it's totally irrelevant.
What do you say, Mr. Runge?
Well, I think it is relevant. I think it goes to show that there's really no basis for the testimony that came in here.
So the question is, what's the basis for the testimony? If Mr. Healy is an intervener or qualified to be an intervener, he'd be a party witness. And if he were an expert, he'd be an expert witness. And I guess your point is he's neither of those.
He's neither of those, and he just has the cover of the town on his testimony saying he's a witness for it, but I don't see any basis for it.
Okay, well, that's an issue that you can address in your brief. Our standard here is we do not have the Energy Facility Siting Board does not adhere to the rules of Massachusetts evidence, but the evidence hearings aren't, the evidentiary restrictions aren't completely irrelevant. But I think this is more, what we've got here is a legal issue. And therefore I'll let you develop a record on it, and you can, based on that record, you can argue whatever you want in your brief.
Thank you, and that was my intent. So again,
I'm sorry, but forgive me just a minute. I've got another technical issue. Just a moment. Right. Thank you very much.
sure thing. The town's attorney, Mr. Pucci, explained on the first day of these evidentiary hearings that you and the other resident witnesses are, quote, testifying in their personal knowledge as area residents who are going to be affected by this facility. But your testimony does not actually contain any information about how you personally could be affected by the project, does it?
that's correct.
All right, are you aware of that several of the third round of EFSB information requests were based on your pre-filed direct testimony?
Would you repeat that?
Well, sure. There were several information requests in the third round from the siting board that were based on your pre-filed direct testimony. Are you aware of that?
No, I'd say I'm not.
Okay. Well, I'm just going to list them here just so that they're on the records. These include EFSB A-6 regarding a haze monitoring plan, EFSB-CM-37 regarding construction management, EFSB-G-23 regarding non-EJ populations, EFSB-S-4 regarding hazardous waste and oil, EFSB-S-5 regarding soil management and activity and use limitations on the Brayton Point site, and EFSB-W-21 regarding water quality and data the company will use to support its water quality certification. That's quite a mouthful. That's the list that your testimony generated in terms of additional information requests. So my question here on this is, have you read the company's responses to those data requests regarding how the company has addressed, is addressing, or will address your concerns, or why the concerns are not based on a correct understanding? Have you read that testimony or those responses?
I did
I'm
not.
sorry, read that testimony or what?
Or those responses?
No,
Can you tell me the reason why you have not?
there is a tremendous volume of information and I've not gotten through it all.
Well, these particular ones that I just cited to you were all in direct response to your testimony regarding concerns that you raised. So I just thought that maybe you would have an interest in actually reading these ones. Did your attorney not direct you to these?
I object. Now we're getting into the substance of communications with counsel. I should note too, I'm going to reiterate about relevance, because is there any implication that I've failed to respond to information requests? My witnesses are not required to do homework unless I'm directed by the citing board to have them do that homework. And I'm unaware of any outstanding requests that I have not responded to. And what I provide to my witnesses or do not provide to my witnesses is privileged information. And I object to the line of questioning. I object to the specific question, and I'm providing notice that I intend to continue objecting to this line of questioning.
Mr. Ranj?
Well, thank you for the notice. I'm really just trying to determine whether Paul, as he is requested to be called, has actually looked at any of the responses from the company that reply directly to the concerns that he's raised, and it goes to the relevance of his concerns.
I have no objection to that question.
Right, but your question, Mr. Ranj, was did your attorney not direct you to review these answers to information requests? And that gets into, that's essential of an attorney, the communication between Mr. Pucci and Mr. Healy. I know you said you're dubious about the attorney-client relationship, but Mr. Pucci has said that these witnesses bind the town, and therefore, I think that his claim of attorney-client relationship is current attorney-client privilege, is strong. And I think there's not only is it strong, there's very little evidentiary value in learning about whether or not Mr. Pucci directed Dr. Healy to look at this or that answer to information request. So I'll sustain Mr. Pucci's objection.
And frankly, I agree with it. Take that question off the table. It's a distraction. I'm really just trying to get back to my point of, and I think it's been answered, that Mr. Healy or Dr. Healy has not reviewed these responses that directly respond to his concerns. Is that correct? Again, just so we have it on the record.
That's correct.
Thank you. Did you comment on the company's draft environmental impact report?
Did I comment? Yes, I did.
Yeah. So have you read the company's response to your comments on that draft environmental impact report in what they filed in their final environmental impact report?
I have started to go through that process.
And do you think you'll be commenting further on that final environmental impact report?
Yes,
Thank you. In your testimony, you state that you, quote, welcome and strongly support South Coast Wind's proposal for the redevelopment of a portion of the former Brayton Point Power Station site in Somerset, and to construct and operate a set of transmission connector facilities that will be used to interconnect a portion of the South Coast Wind offshore wind energy generation project located in federal waters, the clean energy resource, to the New England electric grid, unquote. Is that still your testimony?
it is.
All right, I have no further questions for Dr. Healy at this point. Thank you.
Thank you. Do you have any questions for any of the other witnesses?
I do. So I thought on this, the next one is for the actual resident witnesses, the neighbors of the project, and I was going to try to make this somewhat efficient by asking these questions to each of them in a group, but maybe having individuals respond. There may be a couple of questions that will be directed specifically at individuals. Is that acceptable?
Yes, you can direct questions. Well, I'll ask Mr. Pucci, do you object to that?
I don't, I agree with that, and I had prepared my witnesses specifically for that type of process, so they should be well able to handle that.
Okay.
Just so I can say, a lot of my questions might just ask for a yes or no answer, in which case maybe people can identify. I'm not sure how best to do it for the court reporter, wave the hand or something like that, if they agree or not, but we'll work it through and make sure that we get it on the record. So,
Well, I request that, and we mentioned this before, that the people who speak from that room where where there are multiple town witnesses present, people identify themselves first. So just, if you have an answer to the question, say your name first and then give your answer. And that's the best way to have a clear record. So go ahead, Mr. Runge.
great. So this is really to everyone. And I think we've heard a couple of times now that you all as neighboring residents, you're only speaking in your capacity as neighbors or residents of the project. Just want to confirm that. Is that correct?
This is Nicole McDonald. That's correct.
This is Kathleen Souza. That is correct.
Nancy Thomas, correct.
Peter Pelletier, that is
Well,
correct.
just a moment. Nancy Thomas, correct. And
Peter Pelletier, that is also correct.
Patrick McDonald, that's also correct.
Is that everybody?
Yes.
Thank you. And for Ms. McDonald, you stated earlier in your direct testimony that you are a member of the planning board, I think until, you didn't say this, but I believe it's until April 2026. Is that correct?
Yes, Nicole McDonald. Yes, I am a member of the planning board. I don't know my exact term expiration. It's either 2 or 3 more years. Correct.
And I think you stated earlier that you're testifying only as a resident, not as a member of the planning board. Is that right?
Correct.
This is Patrick McDonald. I'd also like to state for the record that I'm a member of the Economic Development Committee for the town of Somerset, but I am not testifying in behalf of my capacity as a member on that committee.
Great, thank you. So, Ms. McDonald, just for you again, I see that Mr. Pucci has you listed as at least one of the witnesses for the town in its responses to the information requests that were filed yesterday, responses from the town. I think you're one of those. Is it correct that you're acting as a witness in those responses solely in your individual capacity as a resident?
Correct.
Thank you. And for Ms. Souza, I think you mentioned that you are, is it an alternate member of the Somerset Zoning Board of Appeals? Is that correct?
That is correct.
And when does your term expire? Do you know?
I believe it's 2025. That's best guess.
All right, so let me move on to the group. Now, for each of you, are you each a neighbor of the Brayton Point location where the project will be sited?
So this is Nicole McDonald. If you look at an aerial of where the Brayton Point property is located, and when I say Brayton Point property, I'm referring to the entire 300-acre parcel. SouthCoast Wind is proposed to be sited on approximately 10 acres on the northern portion of the property. The residents who are here, with the exception of Mr. Turner, but the residents live directly across from that property. There's a small body of water that we call the creek that separates the industrial site from the residential neighborhood. So speaking for myself, we all drive, there's one road to access the Brayton Point property as well as the Brayton Point neighborhood. So we all use that same access road to drive past the property. So we would be driving directly past the converter station, and then you take a left to go down into the neighborhood. You go straight to go to the Brayton Point property. But we are, when I walk my dogs at night, I can see the property. I believe Mr. Pelletier has direct view of it. Ms. Thomas is looking directly at it. So we are all separated by a very small body of water.
Great, that's helpful. Thank you. So I think you all live, or each of you live within about a mile of the site. Is that right?
Could I answer that, please?
Sorry, who is this? Oh, thank you.
My name is Patrick McDonald, and I frequently walk that neighborhood. So from my house to the corner of O'Neill Road and Brayton Point Road, where the converter station will be located is 1/2 mile from my house.
Okay. Have you measured that?
Yes, I measure it on my Apple iWatch. If I want to stay in the neighborhood, I'll just walk up to the corner and back, and that's 1/2 mile. The berm, the end of the berm is right behind where you propose to put the converter station.
Are you
It will be visible. It will be visible.
I'm sorry,
This is Patrick McDonald. It will be visible at the corner of O'Neill and Brayton Point Road. It will be visible at the corner of O'Neill and Brayton Point Road. You'll be able to see it when you walk by. There's a gate there, and the converter station will be visible as you walk by.
Thank you. Do you know, sir, whether you are the nearest of the residents to where the project site will be?
Probably Peter is probably the closest one, but we're all within that general 1/2 mile area. Kathy lives close to me. Nancy's more closer to Peter, but we all have to be within that 1/2 mile to the actual converter station. Nancy probably lives closer to the dock area, but that's away from the converter station. Your converter station is going to be on the northern portion of the property. And just so the siting board knows, directly across the street from on Brayton Point Road, the residential district starts. So there's actually a lot right across the street where the residential district starts.
All right, so Ms. McDonald, you mentioned a berm, and I think there is a berm that separates location of your property from the site of the converter station. Is that right?
No, the berm separates the Brayton Point property basically from Brayton Point Road. It doesn't, it's not even close to our property. And I will let you know that the berm doesn't help with noise. We've been listening to rock crushing operations that are even taking place further west on that property for 4 years now. And the berm doesn't help with noise reduction.
So have you all lived as neighbors to Brayton Point for several years?
I've been there since 2014.
Yeah, so
everyone should be able to. I just want to remind Mr. Shams and Mr. Brock, I'm sorry, this is Attorney Pucci. I just want to remind my witnesses that are in the same room, a lot of Attorney Runge's questions now are directed to the group. So I want the group to be able to slow down, and if somebody has something to add that's responsive, they should weigh in. You know, just keeping in mind that the court reporter is taking down testimony, so try not to interrupt each other, but please give each other the chance to add anything relevant to in response to the questions.
That's very helpful. That's true. And also, as I mentioned before, it's best to state your name before you answer, but go ahead.
So this is Peter Pelletier. I'm probably the closest. I'm several hundred feet from the property. Just for an example, when the cooling towers were there, which is very close to the property they're going to, the property that SouthCoast Wind wants to build on, about 7 o'clock every night, a shadow would come up my street like a sundial. And so I'm close enough to the property to where that shadow used to actually go up my street. I could have put chalk on the road and tell the time by it. So I'm very close to the property. And as been already been mentioned, in the cooling tower area, which is also very close, they've been breaking rocks. They've been tapping on walls with little hammers. There's been a lot of activity going on in the cooling tower area, and that is absolutely hearable in the neighborhood, not just as close as I am, but much further away. And periodically somebody will hear it and I'll say, yep, I recognize that sound. So that berm is not an effective sound barrier, and nor do I expect it to be an effective dust barrier. As dust rises up and then settles back down into the neighborhood, it won't have any trouble going over that berm. So, and as I believe I said somewhere, the dust coming from there is not just dust. It's a brownfield site. So that dust is all kinds of toxic material. If you have a standard construction site and someone's digging, yeah, you might get some topsoil dust or some dirt dust, but that is not what we're talking about from that site. So I'm very close to the site and I've been exposed to all that.
Okay. Well,
Hi, Kathy. Kathleen Souza. So my house is 2 homes over from the McDonald's, but I also am up at a higher elevation than their home. My second floor, I can see the property from my second floor, specifically the west side of my house, and the west side bedrooms overlook where this converter station will be. The berm would not, in that case, even remotely be a buffer for noise from that location to the second floor bedrooms of my home. And to reiterate what Peter is saying, the dust from that side, I mean, it's well-known PM2.5 dust travels quite a bit. I mean, it's not just our neighborhood, it's half the town, Swansea, Somerset, and the Bay. So my concerns with I think I heard in some of the hearings, I'm not worried about dander and, I'm mostly concerned about the contaminated dust that is recorded on that site and the operations itself with the disturbance of that dust.
thank
I'm
you.
Nancy. I am Nancy Thomas. I live on the west end of Ripley, so I'm situated close to the dock as well as the salt marsh, which will very closely be located to where the converter station is proposed. And I am subjected to the noise from the rock crushing, formerly the scrap metal. Anything that happens there pretty much affects my property because of the little inlet. The way it's designed is it carries the sound into the neighborhood. It echoes very loudly. As for the dust, I went through the coal dust, and when I tell you my basement was covered with coal dust, we would literally have black footprints in our house if we walked into our basement and came back into our property. And then it was the scrap metal dust, and it was the same thing. It covered our house, it covered our cars. It wasn't as much in the basement as the coal was, but I still have the same concerns that that site is contaminated. I lived through 2 of them now, 2 of the businesses that were polluting the neighborhood. And a 3rd construction is just too much to ask of us. I am worried about my health. I'm currently on medication for breathing issues. My doctor tells me my blood levels have elevated signs of metals, zincs, mercury, some things that were on the property with the scrap metal. And I'm afraid that construction is going to kick this up again, and it's going to get even worse for me. So I am very, very close to the property. I have concerns not just for me, but for the neighborhood children, the elderly people. It's really frightening to me that we're going to be subjected to this again.
Mr. Shea,
Yes.
I think we're getting a series of monologues. It's helpful to get some information, but my question was actually, have you all lived as neighbors to Brayton Point for several years? We could have the court reporter read it back if you like.
I understand your point. So the question was, have you all lived as neighbors in this area for several years? Could I just get a yes or no answer from each of the witnesses?
Nancy Thomas, I've been there 50 years.
Peter Pelletier, I've been there for over 30 years.
Kathy Souza, I've been there over 30 years.
Nicole McDonald, I've lived there since.
I'm sorry, I'm having trouble keeping people straight. Ms. Souza, could you repeat your answer, please?
I have been there over 30 years.
Thank you.
Nicole McDonald, I've lived there since 2014.
Patrick McDonald, I've lived there since 2014, but have been a resident of the town of Somerset for 25 years.
Thank you.
Well, so it sounds like from that response that all of you have been neighbors to the Brayton Point site during the time that there was an active coal-fired power plant there and a scrap metal recycling business in operation there. If there's anybody that disagrees with that, please speak up. Okay. Are you aware that the Brayton Point site where the project will be located is zoned for industrial use?
This is Nicole McDonald. Yes.
Kathleen Souza, yes.
Peter Pelletier, yes.
Nancy Thomas, yes.
Patrick McDonald, yes.
Is there anyone among the group that is opposed to any construction at the Brayton Point site?
This is Nicole McDonald. I'll take that. The residents have, I'll speak sort of in general terms, and this includes my opinion. I think Somerset in general, including the Brayton Point neighborhood, we welcomed the owner of the property when they came to the town and told the town that it was going to be developed for offshore wind. What we were shown in the depictions, what the town residents were told, isn't what we ended up with. I don't think, I'll speak for myself, I'm not opposed to that property being developed. What we're asking for, and really all we've been asking for and we continue to ask for, is that on a site of this size and scale, 300 acres of contaminated industrial property located on the bay, surrounded on all sides by densely populated residential neighborhoods, we're just asking that all the protections that are in place through federal law, state law, and most importantly, our local bylaws are applied. If there's any project where all the safeguards should be put in place, it's a project such as this. And we just want to make sure that there is that protection. So if the rules are followed, if the protections are there, what happens on the Brayton Point industrial site should not have an adverse effect on the residents. And that's all we're asking for. We're asking to live side by side, but we are residents that own properties in residential neighborhoods. We have the right to clean air, clean water, to have our children grow up and be healthy, to sit in our backyards, to not be forced in on a hot day like this, to close our windows. And keep in mind, a lot of the residents don't have air conditioning. So all we're asking for is for our rights to be looked out for us to be protected. We want to be healthy. We want to live in Somerset. We're taxpayers. We're just looking for that balance. And I don't see why that can't be accomplished.
This is Patrick McDonald. I don't think that I've ever been against any construction on that property. However, really, it should be in compliance with our zoning bylaws, and it should be in compliance with our Board of Health regulations. And like Nicole touched on, when we saw the original renderings of what the converter stations would be, they looked like they were going to be built in what I'm going to say looks like the Opera House in Australia on the in Sydney on the harbor, and it was this really cool looking building. And I thought, okay, that's going to be something that shields everybody from the noise and electromagnetic fields. I hear this project is 75 years on Brayton Point, and it's just going to be outdoors behind a fence. I don't know why the building suddenly disappeared, and I'd be more amenable to this project if they had a building and that the cable wasn't threaded through a needle through the activity use limitation areas that exist on that property, but that the converter station was more west where the walls to the tower were, and that's where they were originally proposed. And the horizontal direct drilling would be a much shorter route to get to the the DC converter station.
All right,
And-
thank you. I'm sorry. I really have, my question on the table was, do any of you oppose construction on the site? So that was the, if somebody does oppose construction on the site, I'd like to just hear that. I haven't heard.
So I just want to add to my answer. I apologize. This is Nicole McDonald speaking. I just want to add to my answer. As a member of the planning board, I voted to give a favorable recommendation on the Prismium plan development that came before the planning board. I also voted I voted in favor of the preliminary subdivision for the Prismium site. So, and that's in my official capacity as a planning board member. Mr. Turner is also a planning board member. He voted in favor as well. So I just want to make it clear, I'm not opposed to responsible development of that property. And then I'll ask the other witnesses to give their answer to that.
Kathleen Souza.
All right,
I'm
hold on a second. One witness does not get to ask other witnesses to respond. So, Mr. Shea, do you want to impose a little order here?
Actually, I object to that statement that SouthCoast Wind witnesses do that often and perfectly reasonably. Sometimes somebody will give an answer. They think other member of the panel might have something further to add. And they've commonly asked, Ms. So-and-so, do you have anything to add? There was nothing improper about that statement from Ms. McDonald, who's sitting in the same room with the other witnesses.
My concern is to have one witness ask another witness a question. I don't mind having witnesses add to an answer. I object to having one witness ask another witness a question.
So Nicole McDonald, I don't believe I asked a question. I yielded the floor to Ms. Souza if she wanted to provide an answer to your question.
I think that's appropriate. But you understand, I'm speaking to the witnesses. You understand Mr. Runge's objection that he doesn't want you to ask another witness a question. But I do find a lot of merit in what Mr. Pucci said, which is that the town witnesses all the time yield the floor, say, oh, the other witness and give a name may have more to say on this matter. And that sort of thing has been what we've been doing for the last 5 days of hearing. So I don't think there's anything wrong with that, but I understand why Mr. Runge doesn't want a direct question asked. And I agree with you, Ms. McDonald. I don't think you asked a direct question of another witness. So Mr. Pucci, let me ask you, do you object to this distinction? There's nothing wrong with yielding the floor to another witness or saying another witness may have more information on this. But as far as asking a direct question, that's something that's best avoided.
Yes, correct. I agree 100% with everything you just said.
Okay, all right. So I think we have an understanding of how we go forward here. So who was speaking?
Mr. Chairman, Nicole McDonald, I had just yielded the floor to the other residents if they wanted to answer Attorney Runge's question.
Okay.
Kathleen Souza. I'd like to answer Attorney Runge's question. I am not opposed to development of industrial sites, Brayton Point included. to reiterate what Ms. McDonald stated, I would like to see responsible development. I'd like to see our local bylaws followed, our local noise ordinances followed, and state and federal laws followed in that development. And what I'm reading is a little upsetting to me to see that there is a push to bypass our local boards in order to, some of the statements I've heard, and I believe I heard them correct, that, you know, they can follow the noise bylaw for the state of Massachusetts, but the local noise bylaw may be difficult for them to follow. And I find that to be a little disturbing that, you know, you can't find a way to mitigate noise in your construction. I think that's imperative that we mitigate the noise, the dust, the light pollution. It's an industrial site. I live in a residential site, and I want that distinction made.
Thank you. Can I? Go ahead.
Nancy Thomas, I am not opposed to construction that remains within the town bylaws without exemptions to protect us.
This is Peter Pelletier. I also am not against development, industrial or otherwise, but the EPA, the DEP sometimes don't have enough eyes, and some of the violations that have happened over there have actually had to be pointed out to people. But the last thing in the world I would want is our bylaws not to be followed as well. There have been so many issues over there in the last 3 years that it's very clear to the residents, and should be to a lot of other people, that the bylaws need to be followed, the EPA laws need to be followed, the DEP laws need to be followed. All that those rules are there for a reason and shouldn't be bypassed. I've had several discussions with people from SouthCoast Wind during some of their presentations, all very nice people. We've had some really good discussions, and they've all made it clear that they intend to follow the bylaws. Their intent is to follow the bylaws. So if their intent is to follow the bylaws, then you don't ask for an exemption to the bylaws, you just follow them. So the answer to your question is I am not against developing the site, but I do think that it needs to be developed following all the existing laws, and maybe throw in some moral rules in there as well, and go a little above and beyond. That's it. It's Peter Pelletier. Thank you.
Anybody else?
Patrick McDonald again. I would just like to point out that, you know, as far as the building of that, if you take a look at the town of Somerset's noise bylaw, it's a two-part bylaw. It talks about noise, and it talks about being a nuisance type of noise and prolonged noise. And then it says, or comply with those decibel levels. So it's a two-part definition, the noise bylaw. So long as the building is constructed to comply with the noise bylaw, it's simply not a decibel reading. It's a both. There's a catch-all about what the bylaw actually says. The bylaw doesn't just say a straight decibel level at times. It says that it has to be not noxious and not intrusive to the neighborhood, or be within these decibel readings. So it's just not handled by the decibel readings. There is a two-part analysis in that noise bylaw, and I would like to see the converter station constructed to comply with that noise bylaw. Thank you.
Mr. McDonald, while I have you there, can I follow up on something you mentioned earlier about seeing some renderings about what might get built on that site? Those renderings were not from SouthCoast Wind, correct?
No, those renderings were from Ann Barrick, but it's my understanding that when Ann Barrick, I've been involved in this since day one. I've attended hundreds of hours of meetings. I've studied every document you could possibly imagine about Brayton Point. But as far as those renderings, it was Ann Barrick. And when Ann Barrick decided that they weren't going to stay in the project, then Mayflower Wind bought its assets. So didn't Mayflower Wind basically take over what Embark was proposing? And then now SouthCoast Wind morphed from Mayflower Wind. So I think that, what we were sold, we think that was going to be the lineage of whoever was going to build it. So, no, it wasn't SouthCoast Wind, but SouthCoast Wind purchased the whatever rights it had under Mayflower, and Mayflower purchased that from Embark.
So you don't know what South Coast Wind actually purchased from Embark, or what South Coast Wind's intent was for development related to what Embark intended, correct?
Well, I've seen on the Registry of Deeds at the memorandum of understanding that I think maybe it was Mayflower who put that on record. It looked like a hand-drawn sketch, so it wasn't very detailed. And I've attended basically every single public outreach meeting via Zoom when it first started during the pandemic, and I think Kelsey was the one who presented on that. The only one that I did not attend was one about a month ago at the Town of Somerset Meet and Greet Library. But South Coast really hasn't proposed. They give you a 15-minute presentation, but it's not very detailed, and it just skims the surface. I mean, it's really not informational. It's not scientific, and it's basically, I'm going to call it propaganda.
You also mentioned something about crushing rocks on the facility. That's not South Coast Wind crushing rocks currently, right?
No, I use that example because South Coast Wind, I've seen on their sketches at some of these informational meetings that suddenly sound goes from 85 decibels at the location of the converter station, and within 50 feet is down to 55, and then suddenly hits that berm, is in compliance with, they say is in compliance at like maybe the high 40 decibels at the residential, well, they say at the industrial border with the residential area. It doesn't really continue on into the residential area. And I just think that I don't believe that those renderings are correct. I think that that berm is never going to shield the noise the way that South Coast Wind is trying to tell the Energy Siting Board, and I would hope that the Energy Siting Board does not let this be an outdoor facility.
When you say not an outdoor facility, I'm not sure what you mean.
Well, your converter station, like I said, in Embark, I don't see why it's not built in like a dome, concrete type of shielded facility. If it's simply converter and electric stations like you see in normal substations that are exposed on a much smaller scale, they at least have some type of corrugated building. I mean, we're talking about 1,200 megawatts, and I believe South Coast Wind wants really 2,400 megawatts. And now we've heard from National Grid that they also want to bring in 1,200 megawatts. So into Brayton Point, and then have another converter station north of the Braga Bridge. We're talking about potentially 3,600 megawatts coming into Brayton Point, a half mile away from each of our homes. I'd like to know where in the world that ever existed. Brayton Point Power Station was 1,600 megawatts, can divvied up between 4 generator stations. One was 600, one was 400, one was 300, 2 or 300. I don't think they ever fired at the same time for the last 10 years. And now you're asking the residents to be subject potentially to 3,600 megawatts. And I don't know the scientific data, but if you're going to convert down to 3,600 megawatts, how many raw megawatts are coming through the DC cable? 4,000, 5,000 to convert it down? I think that the Energy Siting Board shouldn't just look at this 1,200 megawatt, but what the overall project's going to be, maybe potentially for 75 years.
All right. Well, in my view, that response was not responsive to my question, so I would just move to strike that response.
In my view, it was responsive, so I would oppose the motion to strike.
We very rarely strike responses. I mean, if a response is irrelevant, then we take every response, every testimony. We take give the evidence that it's worth, And there was a lot of factual information in it's Patrick McDonald, right, Mr. McDonald?
It is, Mr. Shea.
There was a lot of factual information in Mr. McDonald's response. I think it's useful to have that in the record. And I don't want to strike it. I won't strike that testimony.
All right.
Thank you.
Well, I think a final question for the group there, and that is that there's been a lot of information that has been put in recently into the record in response to information requests that particularly responded to the concerns raised by the town and by each of you, really. And I'm just wondering, have you looked at the responses from the company where they have specifically explained how they will avoid, minimize or mitigate impacts from the project, including those kinds of concerns you've raised?
So this is Nicole McDonald. I'll start and then I'll yield the floor to the other witnesses. I have reviewed some of it, not all. I am a limited participant, so I do get copied on the materials. This hearing has been fast moving, and I want to thank the Siting Board for the amount of information that they've requested and for all of their questions throughout the hearing. The concern with SouthCoast Wind's responses, and I watched through the live stream the earlier days of testimony, the responses are always phrased in the term of, we'll use best practices, we'll comply to the extent practicable. Who decides what's practicable? Everything was phrased in the sense that we'll do our best, we will try. But where does that leave the residents? Who decides if it's practicable? Is that a cost analysis? Is that the technology exists? Is it based on protecting the residents? SouthCoast Wind has repeatedly argued that they are concerned with the hypothetical appeal and the risks from a hypothetical appeal if they go through the local boards. And they're concerned that that's subjective. Their answers at a 30% design is subjective. These are hypotheticals at this point. So when I hear we'll do our best, we'll use best practices to the extent practical, if it's feasible, when all is said and done and the station is built, you still have residents that if they can't sit in their backyards, if they're being doused with contaminated dust, if they can't breathe, if they're getting sick, if they can't sleep at night, to the extent practicable does not protect the residents. So what I have reviewed in the responses does not satisfy my concerns. I am asking and advocating for there has to be specific conditions. And that's why the local boards, for example, the zoning board, when they approve a plan development, they put specific conditions in place. Those conditions are intended to strike that balance, allow the industrial property owner to use their property for the uses outlined in our zoning bylaws, but have those specific limitations, hours of construction, who's reviewing the construction management plan, will they comply with the noise bylaw, will dust be contained, so that the town participates in that, the residents participate in that, the protections are in place. And so if there's an issue, we're not left with SouthCoast promised they would do it to the extent practicable. We have an actual protection in place. These are the hours. This is the standard. This is what we're complying, so that we're all working on a defined roadmap that the residents know what the issues are and what the conditions are. The petitioner and the property owner know, but it cannot just be left up to, we'll muddle our way through. This property, as I mentioned earlier, it's 300 acres of industrial land that was formerly the coal plant. That property changed ownership in 2018. It has been 5.5 years of demolition, construction, taking contaminated construction materials and spreading them over the site to grade it. dismantling a wastewater treatment facility and removing stormwater systems. And now we've gone through that for 5.5 years with the winds blowing up the Mount Hope Bay, hitting that property and blowing onto the neighborhood. And it's all been done with no protection, so no oversight, no licensed site professional on behalf of the town, no industrial hygienist, no testing of what the residents have been breathing. So we're asking that we need that definitive. It can't be left to, we'll figure it out once it's built, or we'll figure it out when the trucks are running and when the soil's being disturbed and blown. This has to be all planned out very carefully. And just the last thing, South Coast Wind said in one of the earlier days that they're concerned the town has a quote appetite for litigation. And my personal opinion, nothing could be further from the truth. The town has been, in my opinion, dragged through litigation at the movement of Brayton Point LLC as the owner of the property. The town didn't ask to go through a 5-day land court trial. The residents didn't ask for that. The Brayton Point LLC has had to have enforcement by EPA, DEP, the Massachusetts Attorney General's office. This is not the residents or the town having an appetite for litigation. We just want to exist. The town is a small town. The boards are volunteer boards for the most part. You know, we're doing our best to go through this process, but we need to be able to control that process and participate in that process by enforcing our local zoning bylaws, the noise bylaws, the Board of Health regulations, the conservation bylaws. We're just asking for us to have our rights kept in place. I'll yield the floor.
Nancy Thomas, to respond to Attorney Runge's question, I don't believe that the responses to my concerns have been met satisfactorily. On April 20th, I attended an in-person meeting, and I do follow what I can online, but I attended an in-person meeting held by SouthCoast where I directly asked, I believe it was Ms. Perry and possibly Ms. Smith, on how they were going to control. Or let me backtrack. They said that there were going to be 3 to 4 years of construction with up to 100 decibel spikes. When living with the scrap metal on the bad days, it was 80, 90s, and that was really, really difficult to live with. We had windows closed. So when they said 100 decibel spikes, I believe I stood up and said, that's unacceptable. How are we going to deal with this? And now I hear recently that they're saying they're going to be able to control it and get it down to 55 decibels and 40 decibels. But I have no explanation how that's going to happen when they stated publicly that there were going to be years of 100+ spikes. So I'm not sure that they're going to be able to control the noise levels. And I'm sure they're not going to be able to stay under 40 decibels with any type of construction. So I don't think that I've been given an appropriate answer as to how they intend to go from 100 decibel spikes down to 55 and 40.
Kathleen Souza. I agree with both Ms. Thomas and Ms. McDonald. I read what I can. I work full time. I come home and I go through the documents as much as I can. I also have attended almost all of the in-person, I call them meet and greets. I agree with, I think it was Mr. McDonald's statement of they're pretty generic PowerPoints, talk about bringing jobs to the South Coast, talk about, they're going to be good community members. Again, what Mr. McDonald called propaganda about how they're going to be, a great neighbor. Yet, to reiterate what Ms. Thomas is saying, there is nothing in place other than a promise to, do best practices. We cannot afford, our health cannot afford for there not to be somebody watching what is going on. Dr. Healy talks about the vibrations, right? So those vibrations 24/7, how are those going to, affect the residents in the nearby communities? And the constant hum that comes from a converter station. Like Mr. McDonald stated before, why can't you enclose your converter station to minimize that constant hum that the neighbors are going to be subjected to 24/7? Our seniors, our children, myself, we live in a residential neighborhood. I pay the same residential tax rate that across the board. I don't pay a lesser tax rate because of an industrial site that's nearby me. And I'm afforded the same clean air, clean water, quiet sleep for our children who on school nights want to go to bed at 7 o'clock and not be waking up. It's going to affect their schoolwork if they say, okay, well, there is no pre-construction noise level protections in place. That is an irresponsible answer to me. That not only is it not satisfactory, some of the answers I find to be completely irresponsible and disrespectful of the neighbors and the process.
Yeah.
So this is Pete Pelletier. The only thing I'll add is that in addition to what Mrs. McDonald said, one of the other things that I've often heard is that some of these contractors and vendors haven't even been selected yet. So we can talk about the noise they're going to generate. We don't even have the methods they're going to use. Until you have the people who are going to do the construction, until you have these vendors and contractors, in some cases, they don't even know the methods that are going to be chosen to do some of this work. And so it might be premature to try to claim that, your decibel levels are going to be X and your ability to control dust is going to be X. If you don't even have the methods yet, so that you can determine what the mitigation is going to be for those methods. So again, that's the reason that we need to have all the bylaws available, the rules, the regulations available. And we don't want to watch every moment of the construction out there. We want you guys to do what you want to do, and we want to do what we want to do. And we want to trust, but it's after everything we've been through, it's a little difficult to trust. So I would love to see that property completely filled with whatever it's going to be filled with, so that we can eventually have a day of peace and quiet and no construction. But there are slated to be 20 plus projects going on out there eventually. So it's as Mrs. McDonald said, we're already 5 years into this, and there's going to be another 3 years and then another 2 years. And these projects really have to be looked at as a whole, because each one is going to contribute to a little more dust and a little more noise. And they really do need to be looked at by the town, using our bylaws, by the EPA and the DEP and the Attorney General, and everybody needs to be keeping an eye on this. And because it is going to be cumulative. I'm already 62. Who knows? I may not even be around when when all these projects are done. But I don't want these projects to contribute to me not being around as well. So anyway, thank you. That's my response.
And can I
then
just,
lastly, this is Patrick McDonald. I am a limited participant in this case, and I also responded to the draft environmental impact report for SouthCoast, and I don't want to say I'm not picking on them. I also responded to the Prismium project draft environmental impact report and their final impact report. To answer Mr. Runge's question, I've seen every document. Well, yesterday we got 500 pages at 5:01 after the siting board signed off. So no, I didn't get to see those, but I'd say that their responses are inadequate because they're only addressing a 30% design. So anything that they say is based upon a 30% design, and they haven't even got past 30%. So I say that all their responses, because I've heard that the technical analyst, who was excellent in this case, said that the siting board basically reviews projects that are 60% complete design. So I don't think any of the responses even come up. I think the responses should be made after a 60% design is proposed to the board. I think that everything they're saying is speculation and isn't based upon a design that the board gets to rule on. And I thank you very much for all of your input on this project. Thank you.
Go ahead, Mr. Ron.
Okay, well, I mean, a lot of sort of misstatements there. I'm not going to try to correct all of them, but I will say that company has already stated on the record that it is going to comply with the noise bylaw. I will say that the siting board has approved and reviewed projects with similar design levels, 30% or even less. Many times you can go into the history of siting board proceedings and see that and look at.
Shay, I object. I mean, is counsel for the project proponent going to be able to argue in response to answers from the witnesses or ask questions?
That's a good point, Mr. Pucci. But I think that some of what Mr. Runge said is relevant in the sense, especially in the sense that he says the company has stated that it will comply with the noise bylaw. That's relevant to the concerns that were raised about the 100 decibel spikes. So,
First of all, they didn't say that. They
Sorry?
didn't say they did not say they'll comply with the noise bylaw. We
let's
spent
get this straightened out. Let's
time
get
on
this
that
straightened
yesterday. First of all, they didn't say that. They were unclear about what they're applying when. They're claiming that there's a temporary exception so that they don't have to comply with anything while construction is going on. And, you know, I tried to keep my mouth shut, but because I didn't agree with the question in the first place, that the voluminous, you know, you can't mistake quality for quantity. And the fact that SouthCoast Wind is now putting a whole bunch of quantity out there and then making a speech to the witnesses that has adequately addressed all their concerns. And then they give a lengthy response saying, no, it hasn't responded to our concerns. I object to, you know, Mr. Runge then testifying in rebuttal to those witnesses' answers. You know, the record will speak for itself as to whether it's satisfied. The witnesses answered his question. He doesn't get to make speeches, and I don't know what the point of the speech is. I don't know if it's to try to intimidate the witnesses out of giving further answers, or whether it's to testify on the record, which is not appropriate, but in any event, it's improper, and I would ask that it not occur and that he just be limited to questions.
Okay, Mr. Runge, your response?
Well, I was really simply trying to correct what had been misstated by some of the witnesses here. And at this point, I really don't have any more questions for this group. I will note that it's 11:35, so does the court reporter want to have a little time off? I do have questions for Mr. Turner before we conclude.
Yeah. Before we get to that, and I will ask the court reporter, I think we will take a break, but you stated that the company, I believe you stated the company will comply with the noise bylaws, and that does relate to one of the witnesses and their concerns about 100 decibel spikes. Is the company's position that it will comply with the town noise bylaw only during operation or during construction and operation?
I think we said that the noise bylaw applies for operation only, and I think there's a record request that asks us to explain the distinction between temporary construction activities and permanent operation, and we're going to be doing that.
Okay, well, I wanted to get that straight. It would be a good time to take a break. Why don't we take a 15-minute break? It's 11:36. So I'll see you back here at 11:51. Thank you.
Thank you.
We'll be ready in a second. Sorry about that. Sorry, we're coming back on right now.
Okay, let's go back on the record, and I just want to get something cleared. Let me ask Mr. Pucci. Who do you represent?
The town of Somerset.
Okay, so these witnesses, are they your clients?
They're witnesses on behalf of the town of Somerset. They're not my individual clients. I don't have a fee agreement or anything like that with any of the witnesses, but they're testifying on behalf of my client, the town of Somerset.
And is the town of Somerset bound by their testimony?
Yes, 100%.
So is there any difference between the testimony that your witnesses are giving and the testimony that we might hear from an expert witness? In the sense that, an expert witness testimony can be binding upon the entity, the party that calls it.
I'm not sure I'm following. Sorry.
If an expert witness in a case says, "Oh gosh, I guess you're right. There really is no patent infringement here," then the case is dead. That's an expert witness. It can be the statement of an expert witness can be an admission of a party. Can the statements of these witnesses be and constitute an admission of a party?
Yes, absolutely.
Okay. All right. I wanted to get that straightened away. All right.
Could I follow up, Mr. Shea? May I just follow up, please, for one moment? So Mr. Pucci, so you represent the municipal government of Somerset, is that correct?
Yes, correct.
Okay. And while several of these neighbors have positions within the municipal government of Somerset, they're not speaking in that capacity, is that correct?
Yes, that's correct.
They're speaking as, other than Mr. Healy, who lives a little bit further away, and Mr. Turner, who actually let me ask this. Mr. Healy lives a little further away. Mr. Turner is going to be testifying as a government employee of the town of Somerset, is that correct?
Yes, that's correct.
Okay. And then the other 5 neighbors.
Can I just add to that? Can I just add to that part? Can I add to that part?
Yes.
Mr. Turner, as opposed to just being a volunteer board member as well, it is an actual employee of Somerset. You know what I'm saying? In other words, he's the conservation and health agent. Somebody like Nicole McDonald, who's a planning board member, that's not an employee position, but certainly the conservation agent and health agent is. But despite that distinction, both of their testimony is binding on the town.
Well, let me just back up for a second. We're a little confused on the relationship here, and we just wanted to get that straightened out on the record. Again, Mr. Turner is speaking as the conservation and health agent. Is that correct?
Correct.
Okay.
Correct. Yeah.
And then we have 5 neighbors who live in a neighborhood fairly near to Brayton Point, who are, while some of them may be members of certain town boards, they are speaking as neighbors to Brayton Point, as abutters or neighbors to Brayton Point. Is that correct?
It's correct, but they are testifying on behalf of the town, on agreement with the town. And specifically at my request, as counsel for the town, I followed up with these witnesses. I made a specific request for them to testify on behalf of the town. And they agreed as I went through this morning with the pre-file testimony. In other words, they didn't do that on their own in their personal capacity. They did it under the umbrella at my request as counsel for the town.
Okay, thank you. That clears that up a little bit. Okay, thank you very much. Mr. Shea, go ahead.
Was someone else starting to speak?
I'm sorry, it was me. I just said you're welcome.
Oh, okay. Thank you, Mr. Pucci. So Mr. Runge was questioning. Why don't we go back to Mr. Runge?
Okay, thank you. I just had one follow-up question to that group of neighboring residents. And that question is, have you been consulted by the town regarding a potential host community agreement, any of you?
So this is Nicole McDonald speaking. My understanding is that any discussions with SouthCoast Wind and the town are either in executive session with the Board of Selectmen or through the town administrator. I personally have had no involvement or information about that.
Okay.
Peter Pelletier, I have no knowledge of that as well.
Kathleen Souza, again, as Ms. McDonald said, I believe that's an executive session.
Nancy Thomas, I have not.
Patrick Donald, I have not had any discussions about community host agreement. However, I know that there are community host agreements that have been proposed maybe to Portsmouth, Rhode Island, and I've spoke about those before, just generally, but not in any capacity with the town. I'm not part of their executive session or talk about that whatsoever. But I would hope that the South Coast Wind would enter into a community host agreement as a resident.
Okay, is that everyone?
That's everyone in this room. Dr. Healy is at a different location.
Mr. Healy, answer that question, please.
Yes, I am aware that there is a discussion. I am not a part of any of that discussion, though.
Okay, that's really all I was trying to get at. So thank you for that. I now want to just round out the questions by turning to Mr. Turner, if I could. So,
Mr. Turner, are you on?
Yes, I am.
And you were part of the people, you were one of the people who was sworn earlier, correct?
Correct.
Okay, so, all right, so I ask your questions, Mr. Turner.
So if I could just, Tim, if you could just continue speaking and then the owl should pick you up so that you're on the screen.
Oh, okay.
I'm just trying to get it to focus on you.
Yeah, okay.
Okay.
I see you now. Thank you. All right, appreciate it. Okay, so let me say nice to meet you, Mr. Turner, and I wanted to ask you first, were you appointed from among various other town agents to speak for the town in this proceeding, or did you volunteer?
I'm sorry, I didn't hear all of what you said.
I was asking whether you were appointed from among various other town agents to speak for the town in this proceeding, or did you volunteer, or did you simply draw the short straw for today?
No, I volunteered, I responded, and I volunteered through our attorney.
Thank you. I assume you know Mr. Ulucci, the town administrator, is that correct?
I do.
Do you understand him to be the chief administrative officer for the town?
Yes,
Do you report to him?
I do.
Do you know if there's a reason why the town did not ask someone from the zoning board of appeals or the planning board to be a witness today?
I do not know.
You did submit a letter from the chairman of the zoning board of appeals with your testimony, correct?
Correct.
Before you submitted that, did you do any personal investigation of that letter with its author or with the company?
No, I've just read the letter and I thought it spoke for itself.
I have to interject, Mr. Shea. This is Attorney Pucci. I just want to caution in advance. I don't want to start objecting again, but you know, Mr. Turner was selected as a witness specifically with my specific involvement in discussions with the executive authority of the town, which is the Board of Selectmen and the town administrator. And I made all the decisions regarding who would be the most appropriate actual town agent to testify, who, you know, might have knowledge about town documentation or things that have been submitted. And I also want to note the decision not to call a zoning board chair or member or planning board chair or member. And I understand Ms. McDonald is a member of the planning board, but she was not called as a representative of the planning board. I do not do that. As a land use attorney, I will typically object to a land use permitting board member testifying in any proceeding, because typically they're following the same type of adjudicatory decision-making process that your board is. And typically I will object to any of their involvement at all in any type of evidentiary proceedings. And usually the courts agree with me on that, but they don't want to hear from actual board members. They want to hear from witnesses with something to offer, building inspectors, town planners, individuals like that. So I just want to make that clear on the record, that the decision-making with regard to who gets called as a witness on behalf of the town is entirely made by council in
Okay,
consultation with the town administrator and the Board of Selectmen.
thank you. That's a good point. I appreciate it. Go ahead, Mr. Runge.
All right, thank you. And I think what I had asked last was, did Mr. Turner do any personal investigation of that letter with its author or with the company? And I think he said no, that the letter spoke for itself. And I'll just follow up by asking, you know, the letter itself makes some pretty strong, uses some pretty strong language against the company. And my question is, do you think that reflects any bias against the company on the part of Mr. Carteret?
I didn't hear that second part. I heard you up to bias.
Well, I was asking you whether you think the letter itself and the language used in it reflects any bias against the company on the part of Mr. Carteret, the chairman of the Zoning Board of Appeals.
No, I do not.
So that letter was addressed to the town administrator in his role as chief administrative officer for the town, correct?
Yes.
Did you speak with Mr. Alucci about that letter?
Just the body of the letter. We didn't get into any yes or no conversations about it.
Did he ask you to look into it at all further?
No.
Have you had any discussions with representatives of the company about the project?
Yes.
And who have you spoken with?
I've spoken with Kelsey. Is it Kerry? I'm sorry, I don't remember what your name is. Kelsey Perry, was that?
Yes. Anybody else?
Is it Kerry?
Kelly Smith, I think, is the other person you're referring to.
Kelly, yes.
Okay. Thank you. I'll ask you what I've read, ask some of the other witnesses. Have you read the various filings made by the company about the project, and particularly how the company will develop and operate the project so as to avoid or minimize or mitigate impacts to the town and its residents?
I've read them. I can't say I've read everything completely, but I got the picture.
Have you been listening to the hearing during this week at all, or last week?
Very little. It's during the workday.
So I understand from the company that the town administrator, Mr. Ulucci, has been the point person regarding town interactions with the company about the project. Have you spoken with the town administrator about the project?
Very limited. Just in the two times that we've met with Kelly and Kelsey, just light discussion. It was nothing official. It was just more of a informational type sit down.
They try to answer your questions that you had at those meetings?
Yes,
Have you been involved in any discussions about a potential host community agreement between the town and the company?
no, I have not.
So you stated in your pre-filed direct testimony that the town does not oppose the project, correct?
Correct.
On page 2 of your pre-filed direct, provide a list that summarizes your concerns related to the project. And I think you also repeat that same list in your response to information request EFSB-TOS-1 parens 1, correct?
Correct.
And these concerns include management of impacts related to soil, hazardous materials, dust, stormwater runoff, noise, and lighting, correct?
Correct.
So again, I think you've already answered this, but I'll just try again. Did you read the company's specific filings, including its responses to information requests about how it would address those concerns?
Like I said, I did not read them in full.
Would it help you if you read those to determine whether your concerns have been or will be adequately met?
They haven't filed anything with any of the boards yet. So to say perhaps, I suppose is the best answer I can give you.
Just to be clear, though, we are in front of a board right now. It's called the Energy Facilities Siting Board that has jurisdiction over this project and the petitions before it. So those filings that I just mentioned are all here for you to read.
Is that a question?
It's an encouragement to read them. I'll just leave it at that. So, Mr. Turner, your pre-filed direct testimony also addresses zoning and the town's desire that the company go through the formal zoning process, correct?
Correct.
Have you read the company's zoning petition and its responses to information requests from the town and the EFSB, in which the company specifically explains the reasons why it has requested under applicable law to be exempted from the formal zoning process? And that includes a desire to avoid ambiguous or discretionary and subjective application of the zoning requirements and a desire to avoid delay from third-party appeals. Have you read that?
No.
Are you aware that the petition for zoning exemption is a legal option under Massachusetts law and that the company is exercising its right to seek zoning exemptions for the project?
Yes, I do.
I object.
I'm sorry,
That-
go ahead, Mr. Pucci.
That is entirely calls for a legal conclusion. And the town's position is well known on this, is our position, the project proponent has not met the burden to seek or obtain a zoning exemption. And that in fact, the granting of a zoning exemption would be reversible error under the circumstance of this case.
Can I ask Mr. Brock to read back Mr. Runge's last question?
Are you aware that the petition for zoning exemption is a legal option under Massachusetts law and that the company is exercising its right to seek zoning exemptions for the project?
Okay, what's wrong with that question, Mr. Pucci?
It's a calls for a legal conclusion. How can Mr. Turner judge whether they have the right to seek a zoning exemption? He's not an attorney. He's not trained in reading legal pleadings. If he's read the petition, he has no ability to comment on it.
All right, they being the company, when you say they seeking zoning exemptions.
Correct. The question is also irrelevant. Why does a factual witness have to be asked a question about what the zoning petition says? The zoning petition speaks for itself. It's for the citing board to rule on whether they've made out their burden of proof. It's not for a factual witness to comment on that one way or another.
Okay, I understand you, Mr. Runge.
Really just asking him if he's aware that that the company is exercising a legal right it has to seek these exemptions since he cares about the zoning process.
I don't see that the question is really harmful. I understand, Mr. Pucci, your objection that calls for a legal conclusion. The problem we have here with a lot of our zoning petitions is that the witnesses do testify regarding legal issues. I mean, your witnesses were testifying earlier about the need for the zoning bylaws to be enforced. And so that's certainly a somewhat legal issue. So the legal fact distinction is not as sharp as maybe in other cases.
Oh, well, I have another issue about it, which is relevance. How in the world is it relevant that the fact that the project proponent has the legal right to seek zoning exemptions from the siting board? How is this witness's answer to that question relevant? We know that the proponent has the right to seek the exemption. That's a different issue as to whether the proponent is entitled to the exemption.
Mr. Runge?
Yeah, I'd be happy to answer that. So I would just point Mr. Pucci to the Exhibit A to Mr. Turner's testimony, which in fact is all about zoning and zoning, the legal right to do something or go through the zoning process or not go through it. So look at Exhibit A. I think that answers the relevance question.
I think I'm constrained to overrule the objection. I think that the question itself is not harmful. So go ahead, Mr. Turner, if you can answer that question.
I do.
You are aware. That's all I'm asking. Yep. And the answer is yes. Correct?
Yes.
Thank you. All right. I think the final question is really just that, are you aware that in responses to information requests, the company has committed to work with the town to meet the applicable zoning requirements to the extent practicable as it develops and operates the project? Are you aware?
Yes.
Okay, thank you. No further questions.
All right. Let's see, we just got back from a break. We're gone for a while. I was going to ask some questions unless Mr. Wong or Ms. Devakar has a strong desire to start asking questions.
Mr. Shea, you can start. We'll follow up after you.
Okay, thank you very much. I'll ask Mr. McDonald. I
Yes.
understand, and I understand you stated that you looked at the registry of deeds and you found a memorandum of understanding recorded there. Would you tell me more about that, please?
Yes, it recorded in the Fall River Registry of Deeds was a memorandum of understanding, and it really didn't have any legalese or obligations of the parties, but it actually showed and it was really a hand-drawn sketch showing the two preferred cable routes, one being the eastern side, which would be very close to my property and everybody else that's sitting in this room, and then the western side. And then it showed a sketch, and it wasn't a professionally drawn sketch. It looked like somebody hand drew it without any formal training as far as to scale and engineering. And it wasn't a very voluminous, I think it was only one page or two at tops. And that was it. And it didn't have terms of the lease and responsibilities or anything like that. And it's easily accessible online at fallriverdeeds.com.
I'm sorry, it's accessible online. What?
At fallriverdeeds.com, all one word, no spaces. FALLRIVER deeds, DEEDS.com. That's the Bristol County Fall River Registry of Deeds.
I'm sorry. The Bristol County Forum Registry of Deeds.
Fall River.
Oh, thank you.
Sorry.
Mr. Shea.
Yeah, who is that?
Eric runs for the company. Just wanted to ask whether it would be appropriate to have a record request for this document since it's being talked about in this proceeding.
Yeah, I want to make a record request for the document. I know that it's available online, but I can't really get it online and then submit it as part of the record with my own affidavit. So I'm going to ask Mr. Pucci as a record request for a copy of this document. Record request EFSB, and then I'm going to ask Mr. Brock to give me the proper number.
$26.
I'm sorry, 26?
Yes.
So that's record request RR-EFSB-26. It's the document that Mr. McDonald was just testifying about. Tell me, who are the parties listed on the document? Was it grantor, grantee?
I believe it was a grantor grantee. I think it was between Brayton Point LLC, the owners of the property, and then Mayflower Wind.
And tell me why you thought this was relevant.
Well, I was the one who searched the property and found that the Commonwealth of Massachusetts owned the 12.5 acres of tidelands, and actually alerted to the Commonwealth that you've lost your lease on this property, and it finally got acknowledged that the Department of Conservation and Recreation own that 12.5 acres, and it's under lease by I say improperly leased to Brayton Point LLC. I ran titles early in my career. I'm not a real estate attorney now, but I just like to keep track on what's going on the property. There hasn't been a transfer to the property yet to Prismian, the 47 acres. So I periodically go on and check the title to see if there's any updates, to see if there's anything filed by DEP, anything that could be relevant to the property.
Okay, so I understand you got this document. I'm intrigued. And can you tell me, you said there's a sketch in the document. Can you tell me is there any language in the document?
There really isn't any language in the document. If you could hold on 1 second.
That's viewable on.
No, I haven't shared my screen. Mr. Shea, if you could just give me 1 second.
Sure.
So give me 1 minute. It's actually 1 of 5 pages that I'm looking at now. If you wanted to, I could maybe it's the unofficial copies because it's online, but it's in Fall River Registry of Deeds in book 10927, starting at page 49. And it's between environmental liability transfer, the lessor, and it appears that nobody else has signed that, other than it says return to William Pizzoni of Day Pitney LLP at 1 Federal Street, 29th floor, Boston, Massachusetts. And then there is a drawing, and it actually shows the western corridor and the eastern corridor, and it kind of puts the proposed station more in the middle of the north piece of property than where they have it proposed now. And it's Exhibit A to the general site plan that's on here, and it was prepared by, it actually says Brayton Point onshore site plan, and it's dated August 31st of 2021. And it's got a legend to it. So, and that exhibit is attachment 1 to the memorandum of option, they call it. And that's in book 10927, page 53. And it was recorded on, it was recorded on February 23rd of 2022.
That's very helpful. Thank you. I appreciate that information. We'll be getting a copy of that through the record request. Mr. Pucci, do you see any problem providing that? Through the
None at
record
all.
request?
None at all.
Thank you. I appreciate that. I want to ask the town of Somerset witnesses, the group of you there who have testified. There was a lot of testimony, and I listened to it, and there was testimony about noise. And I remember someone specifically talking about 100 decibel spikes. What is your understanding of the town noise bylaw, not the zoning bylaw, but the noise bylaw, and how it protects you and how it regulates activity?
Mr. Shea, Nicole McDonald, I'll start, but then I'll yield the floor. The town of Somerset ran into issues with noise during the scrap metal operation. So a noise control bylaw was put before town meeting and approved by town meeting. The final version was approved in May of 2021. And the reading of it is that it applies to all the properties across town, and it applies to all noise. So my understanding is that noise bylaw would apply to my property. If I was having a house party, it certainly applies to the industrial sites, and it applies to all noise nuisances. And it would certainly apply to construction activities as well as operation. And the way it is written, you have the fallback of the decibel readings, but the bylaw itself talks about noise is declared a nuisance if it's excessive, unnecessary, prolonged, unusually loud, or unnatural in its time, place, and use, and constitutes an annoyance to a person of ordinary sensibility to sound, materially and substantially interferes with the ordinary comfort of life and the reasonable use of enjoyment of property, or fails to meet the standards set forth below, which is the decibel readings. So it's intended to put a two-pronged protection in place, that if you measure at the property line, you can go by the decibels, but it was also intended to address the concerns of noise, where you can have a noise that, if it's a constant noise at a certain decibel that you sort of get used to as background noise, that can be different than, for example, what we ran into with the scrap metal, where you'd have a loud, jarring noise at 2:00 in the morning that wakes people up, and then you don't get back to sleep. So it's intended to give the town the ability to regulate and control noises, both at a decibel level, as well as when they're a nuisance. So when they're really affecting people's ability to sleep or live in their homes. So that's my understanding of it, and I'll yield the floor.
Does anyone else want to supplement that? I think it was a pretty complete answer, but if anyone else has anything to add.
Yeah, that was a very complete answer. I'll just add that.
I'm sorry, is that Mr. Pelletier?
Yes, it is. Sorry. Yes, Peter Pelletier. I'll just add that, the most important part to me as a resident, obviously, is just the nuisance part. I'm not really interested in measuring decibel levels. I just want to know that I can sleep. When the power plant was there, periodically, the pressure would get too high, and they would blow off some steam at inappropriate times. But I was fully aware that was, required so that the pipes didn't blow up. So there are things that, there are exceptions that are okay, but I just didn't want, to be sitting comfortably in my living room and all of a sudden have, bangs or crashes or explosions or things that are just going to, make me jump, things in the middle of the night that are going to make you, jar you awake. That's the part that's most important to me as a resident. So I just figured I'd mention that. So
I just want to supplement that. It's Patrick McDonald again. for the years that we had to deal with the scrap metal operation, I mean, we were really oppressed. I mean, it was oppressive. It was something that anybody who sat on this energy siting board would not want to live near. It was, we're all, I heard yesterday that South Coast Wind says we're an innocent tenant. We're innocent residents. We'll never have the impact on South Coast Wind that they'll have on us. And we don't want to be oppressed. And we want to be able to have the quiet enjoyment of our homes. And I will tell you that we live next to the Braga Bridge, and you can listen to the Braga Bridge, and it's a background noise, and you can still hear the birds chirping. And it's a beautiful day, and you can live with it. If that's the way South Coast Wind's gonna be, great. But if it's gonna be oppressive, we can't have that. We can't live like that. Thank you.
Okay, thank you. One of the important points, Ms. McDonald, I believe you said that you believe the noise bylaw applies to construction as well as operation. Is that correct?
That's correct, Mr. Chair.
Okay, and does anyone else in that room have a different understanding?
So if I could just, so Nicole McDonald, so the bylaw applies to excessive and unwarranted noise that's a nuisance or potential health hazard. It does not carve out an exclusion for construction. There are some exclusions for, the local high school having a marching band, but it does not, contrary to what was argued, my reading of the bylaw is that it applies to everything. So it would apply to a loud house party in a neighborhood, and it would certainly apply to horizontal direct drilling, 2 to 3 years of construction. It applies across the board uniformly to all noise in the town. That's my reading of it.
Tim Turner, yes, that's correct.
I'm sorry, sir.
Tim Turner, yeah, I concur with Ms. McDonald.
Okay, does anyone there disagree?
Kathleen Souza, I do not disagree, but I just want to add further that our zoning bylaws also addressed industrial noise, which supersedes, I'm sorry, I'm not looking at the camera, which supersedes. So 4.2.6 of our zoning bylaws discuss how noise, dust, light, fumes are effectively confined to the property. So they're further discussed in our zoning bylaws and are stricter and supersede that. So there are layers of protection. What's that?
What supersedes what? I didn't understand.
We have zoning bylaws, the Somerset Zoning Board bylaws, 4.2.6 is for industrial use. And that says that all noise, dust, fumes will be confined effectively to the property.
But what supersedes what? Which bylaw supersedes the other?
Zoning supersedes the town ordinance.
The zoning ordinance supersedes the town noise ordinance. That's your understanding?
That is my understanding. I may be incorrect, though.
Okay, and I just want to, I'm trying to get a context.
My point is there are several means to address noise in town of Somerset.
Okay.
And it's not just a blanket for this, it covers everything.
Okay, but I've heard your concerns, and obviously, and I've heard your concerns, and I've heard how much you are concerned, and I'm trying to get a context for your concerns. Now, let me ask you, what's you being the group of people in the room, is it your belief that the zoning exemption that's being sought in this case would exempt the company from the town noise bylaw?
Mr. Chairman, Nicole McDonald, my understanding, and I don't, this is my first and only siting board hearing that I've participated in. My understanding is that the petition filed by South Coast pertains to exemptions from the zoning bylaw. I don't know the answer. This would be for the siting board, but I consider the noise bylaw as a separate town bylaw. I don't know if that's, I don't know the answer, but it is separate from the zoning bylaws. And my hope is that it applies and cannot be waived so that the residents at least have that protection.
Okay, does anyone else want to talk to that issue?
So this is Peter Pelletier, and I just, as I said before, I just see that the town, first of all, I wouldn't have enough knowledge to know which bylaws apply when, and which ones are exempted, and which ones won't be exempted, under what conditions. I'm just a resident. But what I will say is that it's very, very important to me that the town bylaws be available in their entirety, because each one of these projects is going to come into the state, and they're all going to have their individual approvals, and they're all going to get their projects approved or disapproved individually. But I think the town needs to look at this as a whole, and the town needs to be able to control the noise and the fumes and the dust as a whole from the whole property. I expect to see at some point the whole property covered with something. Obviously, they're not going to, any land that's left will be attempted to be filled if it's going to make somebody some money. But I think that these bylaws, whichever ones individually, all need to be available to the town so that this project as a whole can be followed, and these things can be controlled. As if you have one part and you say, well, okay, they have to meet the town bylaw for noise, but this other part, well, they're exempted. How do you even do that? So because then everybody will be like, oh no, it's not us, it's them. My point is, I'm just a resident. So again, I don't know specifically who would be exempted from exactly what, but I know that as a whole, we have the bylaws for a reason. Some of them have been put in recently for very good reasons, and that it's very important to me that all those bylaws are available to the town, not because we do need them, but because we may need them. And nobody knows what's going to happen a year from now, 2 years from now. As I mentioned earlier, there's plans for construction. We don't know who's going to do the construction. When you ask specific questions, you get, well, we don't know what method we're going to use because we don't know who's going to do it yet. And that's going to be determined by the person that's going to do it. So we need to have all these bylaws available so that as we're going along, if we have an issue, we have them available to us to try to address these issues. It'd be nice if everybody could just say, hey, you're making a little noise, can you quiet down? And they quiet down. But sometimes you actually need the bylaws. And I hope that answers your question. Thank you.
Thank you.
Mr. Shea,
Mr. Pucci.
Attorney Pucci, I didn't want to intrude on your questions to the witnesses, but now that they've answered, I just wanted to clarify to you the town's position on this is there's a noise bylaw, which is pursuant to general bylaw provisions of the Mass General laws. It's the town's position that those local noise general bylaw applies fully to this project, both with regard to operations and pre-construction and construction activities. And that the siting board, and I would assume the siting board agrees with this, has no ability to override or grant exemptions over a general bylaw. And further to that, with regard to the zoning bylaw noise provisions that Ms. Sousa talked about, it's our position that that section of the zoning bylaw should not be, exemptions should not be granted to not comply with those provisions of the zoning bylaw as well. But there are two distinct noise bylaws at issue. One is zoning, one is a general bylaw. And with regard to that general bylaw, again, specifically in response to the company's position, it's our position that there is no ability to distinguish between construction and operation when you're talking about application of the general bylaw to this project.
Objection.
Mr. Runge, what's the basis for your objection?
Basis is exactly the same basis that Mr. Pucci raised earlier. That is the attorney testifying on behalf of the town in this case.
Okay, I understand your objection. I'll leave the testimony in, and your objection is in there also. But there's been a lot of concern by residents, and I want to address this. Now, let me ask the witnesses for the company, is it your understanding that the petition, the zoning exemption petition before the board now, seeks an exemption for the company from the noise bylaw, not the zoning bylaw, but the noise, the separate noise bylaw?
Just to be clear, you're asking the company's witnesses, is that correct?
Yes.
I'm sorry, could you repeat the question so I answer properly?
I'm sorry, who is this?
Ms. Smith, sorry.
Is it your understanding that the petition, the zoning exemption petition before the board now, seeks an exemption from the noise bylaw? Not the zoning bylaw, but the noise bylaw?
No, it seeks an exemption from the zoning bylaw.
So is it your understanding that if an exemption from the zoning bylaw is granted, the noise bylaw will still be in effect?
That is my understanding, yes.
Does anyone else, that one of the witnesses have a different, witnesses for the company have a different understanding? Okay, I wanted to raise that issue to address the concerns, to narrow the focus of the concerns regarding noise. Let me ask, now that I have the witnesses here, can someone address the concern that was raised about the 100 decibel spikes?
This is, sorry.
Are you asking the SouthCoast Wind?
Yes.
witnesses? Okay.
Yes.
This is Ms. Smith. That was in reference to some of the construction operations for horizontal directional drilling having periods of activity that unmitigated might reach levels over 100 decibels.
And as a practical matter, do you expect the horizontal directional drilling to reach 100 decibels?
Unmitigated, it is possible that some of the equipment could reach those levels. However, in our record request response currently being prepared, we'll address what it would look like to incorporate equipment silencers on the exhausts of some of the pieces of equipment. And then in a subsequent record request response, we'll address what it will look like to include temporary noise barriers, both of which are mitigations that SouthCoast Wind has previously stated that we would use.
Okay, so just to make this clear, the possibility of 100 decibel spikes is there for unmitigated construction, but SouthCoast Wind has promised to provide mitigation. Is that correct?
Yes, SouthCoast Wind will be pursuing mitigations for the construction activities.
Okay, and when we get the record request, when we get the answers to the record request, excuse me, will they state the expected decibel levels with the mitigation?
The record request responses that are going to come in first are going to provide the mitigation, including equipment silencers at the exhaust. We'll follow up later with the additional mitigations of sound barriers.
Okay, but will we ever get a projection of what the decibel level will be like with mitigation?
Yes.
And I assume that will be less than 100 decibels.
I would assume so, but I don't have those numbers quantified at this point in time.
Okay.
Mr. Shea, excuse me. Can I just confirm whether we're talking about the 100 decibels at the point of the generation of the noise source where the HDD is taking place, or at a more distant location, perhaps at the
Property line,
residence locations in the abutting areas?
This is Ms. Smith. Will be presenting both.
Okay, thank you.
Now, with respect to the noise issue, and I'm going to ask this of the witnesses for the company. What is your understanding of the requirement of the noise bylaw? Do you believe that the town noise bylaw applies only to operations, or does it apply to construction and operations?
This is Ms. Smith. Our understanding is that it applies only to operations, but again, we'll be following up with our official position and reading of the bylaw via a record request response currently being prepared.
Thank you. The witnesses have talked about noise and dust and a lot of problems. These, for lack of a better word, the trials you've been through, the inconveniences that you've suffered have been result of partly of the scrap metal operations. Is that correct?
So, Mr. Chairman, Nicole McDonald, it's actually, so when the property changed hands in 2018, they started with demolition of the power plant, the smokestacks for the power plant, the two 500-foot cooling towers, and it over the last and to the present day, there is still alleged demolition going on site. There's been grading activities, and then you also had the scrap metal mixed into that. So it's been a combination of both demolition, grading, scrap metal. They had a bulk salt operation for a while. It's just been a combination of everything. So I'll yield the floor.
I'd like to follow.
Mr. Shea, Mr. Shea, I'm having a technical difficulty. Sorry. I didn't mean to interrupt, but I've been banging the table because I'm trying to get back on camera. And I just wanted to make sure you knew that. I was just having technical difficulties staying on camera. I didn't want you to think I left the room.
That's okay.
Can you see me here? Okay.
I can see you fine, Mr. Pucci. Thank you.
Okay, I went off camera for a while and I just wanted to make sure I was back on camera because I have not left the room.
Thank you, Mr. Pucci. And I'm just a question from Ms. McDonald. You said there was demolition of the old power plant, there was a scrap metal, and I believe you mentioned a third thing, but I didn't quite catch that.
It was a bulk salt business. So they would bring in essentially road salt on 600-foot break bulk carriers, and it would be offloaded onto the site, piled, and then trucked off site. So similar to the road salt that you would use in the wintertime.
So, Mr. Shea, I'd like to follow up with that. Patrick McDonald.
Yes, sir.
Just along what supplement Nicole said, there were two cooling towers and a smokestack that were about 500 feet. There were two smokestacks that were lower than that, and then the building. And every time that they took down a smokestack or a part of the building that was 400 feet in the air, it was done on a Saturday morning at a moment's notice when everybody was home in their houses. It was always a Saturday at 10:30, 11 o'clock. They gave us no relief, and the amount of dust that was generated from those implosions and tear down of the building would douse the neighborhood with toxic dust. Who knows what it was, but it was never on a day that nobody would be home. It was always on a day. So I've listened to the SouthCoast Winds about the horizontal direct drilling, and they say that's going to last up to 2 months, 24 hours a day at 100 decibels. I don't think anybody wants to listen to that. And then when you look at the document that I referred to from the Fall River Registry of Deeds, that line of horizontal direct drilling is far less extensive than what the proponent has proposed to the siting board. And I don't know why they would go that route with it, because they want to put a cable under the ground for a period of 75 years that's going to run underneath basically every dangerous activity land use area that's on that site, landfills. So if there is a problem with that wire, that cable, they are going to have to dig through landfills to get to it. So I don't think it makes any sense. And I think that the siting board should really look at the memorandum of understanding direction. That would be the shortest and most inconvenient route to their power station. Thank you.
Okay. You've mentioned children. I know let me get a sense of the neighborhood. How many adults and how many children live in your neighborhood?
Kathy, you're probably the best.
So Kathleen Souza, I believe we have a little shy of 100 homes. My guess on it's I would say more seniors than younger families. But as far as families with school-age children, if I'm thinking of the bus stops that go, I mean, I've got 3 next door, we're probably 40 have children. We have multiple families that just moved in with babies
Yes.
that have from newborns to 3-year-olds. That's in the last 2 years, quite a few families with younger, but probably at least, and I'm talking just the neighborhood directly beside this converter station. Within streets of the converter station, there's probably at least 40 families with children.
Okay, thank you. I appreciate that. Yes, go ahead.
I'm Nancy, sorry. Can I just make one more point? I mean, some of the things we saw from the noise too, especially the unexpected.
I'm sorry, some of the things we saw from the what?
From the noise in the past, especially those jarring 100 decibel noise. We do have a resident that has PTSD from serving in the military. And those are things that I think, larger companies don't think about, between waking up babies that are taking naps to that. I mean, it's 100 decibels is extremely loud. So sorry, Nancy.
That's okay. Nancy Thomas, I just want to speak to the children issue. On my street, which is Ripley Street, which is the closest to the waterfront, we had some school children when they were affected by the noise from the scrap metal and the construction, the implosions, that actually wrote letters to the school boards and various boards in town complaining that they were getting no sleep and it was affecting them greatly. There were some that said they were experiencing health issues as well, but it was primarily the children themselves that took it upon themselves to initiate contact with town officials because they couldn't sleep at night. They were having trouble with school. They were suffering the side effects from the noise. And on my street alone, I can think of at least 16. 8 houses.
There's 16 children.
With small
Wait, I'm sorry, just one at a time, please.
I can think
On my
of at
street
least-
alone.
Yes, it's still Nancy. I'm sorry. On my street alone, which is again closest to on the water, I can think of at least 8 houses within a few blocks of myself that have school-age children and younger. But specifically, the children that wrote letters lived basically 10 yards from me. So it is definitely a concern for the families, and I'd like to advocate for them and hope that we don't have to put them through this again, because they turn to us for help as well as the town to seek some relief. But my fear, and I also want to mention that the residents took it upon themselves to raise money to put noise monitors in my backyard directly. I mean, it was there for weeks. So I had a front row ability to see the decibel reading. So I know Mr. Pelletier today wasn't concerned about decibel numbers. I'm very concerned because it was on my patio for about 2 weeks and I could see the spikes and they were horrible in the 80s and 90s. So to consider 100 decibel spikes for myself and the children in the elderly neighborhood is just really heartbreaking, because when we say we had to close our windows and not go outside, we're not exaggerating even a little. I would close my windows and I couldn't hear my television. And I know that's a minor, thing, not being able to hear your television, but when you live it day after day after day, and you can't open those windows in May, June, July, August, it's really detrimental to the ability of the residents to enjoy their properties. So I just want to mention that noise pollution is really important to us down there. And I hate to sound like, we're beating a dead horse, but we really want to just make it so clear to you how important it is to us.
Of course.
Just lastly, Mr. Shea, it's Patrick McDonald. We can't forget our fur friends, because my dogs did not like it at all. They would run back into the house quivering. I think Nancy's dog was on medication because of it. And a lot of people had problems with their pets because you couldn't. And I think that's un-American that you can't walk your pet dog down the street in peace.
Someone mentioned, thank you, Mr. McDonald. Someone mentioned air conditioning and was talking about that not everybody in the neighborhood has air conditioning. I know this is a very general question, but can you estimate for me the number of people in this neighborhood who don't have air conditioning and therefore would be required to keep their, according to your testimony, required to keep their windows shut even during the hot days?
So I'll start with that, Mr. Chair. This is Nicole McDonald. Historically, the Brayton Point neighborhood, originally most of those homes were summer cottages. It was a summer beach cottage community. And over the years, houses have been winterized and converted into year-round homes. So the homes are small, they're close together. In terms of demographics, Somerset is not an environmental justice community, but I think the neighborhood is comprised of hardworking, either blue-collar workers, families with young children, elderly or retired or disabled individuals. And there was testimony during the land court of residents that either didn't have air conditioning or wanted to have their windows open but couldn't because of concerns of not only the noise but the dust coming from the property. So I'll yield the floor in terms of if anyone else knows, but the houses are small, they're close together. It's not a wealthy community. It's not so it's a community of very hardworking people that are just getting by.
Kathleen Souza. I would just say it ranges. I know residents who don't have any air conditioning whatsoever, one being very close to the property, to maybe having an air conditioner that they move around. So at night they can move it to their bedroom so they can sleep. I know one that's, there's at least two that have none at all. So, but there's several that I know have only one air conditioner or had put out the word to borrow an air conditioner just to sleep at night. So
this is Pete Pelletier. So I've been there over 30 years. I raised 4 kids in my house. It's a very small house. It's an old summer cottage. I have 18 windows. So when I first moved in, early in the morning, the windows would be open. At night, the windows would be open. It would, maybe close the windows, keep the cool air in for a while, open them later when you had to. We had a nice breeze off of the bay. So for 18 years, I had no air conditioning. The last 5 years or so, when we started having trouble with not just dust, but toxic dust, I had to start closing the windows. I did go out and buy a couple of window air conditioning units, but the problem with those is once you fill the window with an air conditioning unit, you can't open it after that to get cross ventilation. I'm also 62 and my knees are going, so my ability to carry air conditioning up and down stairs is getting more and more limited. So the bottom line is, you asked about air conditioners. I did not have air conditioning. My kids will tell you that I used to throw them outside during the day, go outside, sit in the shade of a tree. I put a swimming pool so that they could have that in the summertime, but we never had air conditioning until recently, when I was the last 4, 5, 6 years, till I was forced to actually close all my windows, which is a sin to be right next to a bay, a beautiful bay, and have to close all your windows. So that's where I am.
Nancy
Thank you,
Thomas, I'm sorry, Mr. Shea. I just have one more thing to point out with the air conditioning. You asked originally, like, how many could we estimate, how many people? A lot of the issue is that we have a lot of elderly on fixed incomes in our neighborhood, and they just can't afford the electric bills. And that's a lot of the reasons why they don't have air conditioning. So for them not to be able to open their windows is a huge problem.
Ms. Thomas, and tell me if you can't, but can you estimate roughly, there are about 100 homes. How many are occupied by elderly people who don't have air conditioning? 5,
Oh my
10?
gosh. Oh, I'd absolutely be speculating, but I know I can speak for Ripley Street pretty much. We have probably 1, 2, 3, 4, at least 6 on my street are elderly on fixed incomes. And I know there are more up toward Mr. Pelletier's neighborhood, but I wouldn't know the details very much. But I do know the elderly couples and singles that live in my direct area.
And
Just can't afford the electric bills.
are they all without air conditioning?
Not all of them, no. No.
How many
But
are
a lot-
without air
a lot
conditioning?
are. So I can think of like 5 or 6 within Ripley, Swan, which is a couple of streets up to Carey Street. Again, they're small cottages, but it's not that they don't want it. They just can't afford the electric bills. So they opt out of getting air conditioning and open their windows.
But you can think of 5 or 6
Yes.
elderly couples that don't have air conditioning.
Or couples or singles.
Okay.
And there's a family with children right across the street from me that don't have air conditioning either. I actually offered them one about 2 weeks ago because I had an extra one, and she declined because she didn't want to have to pay the electric bill. She's a single mom with a couple of kids, so she actually declined it too.
Thank you. I want to, I know this may, well, I'm not going to apologize. Someone referenced the children wrote letters to the school boards and the various boards saying they can't sleep at night. Is that right?
Nancy Thomas, yes, that's correct.
Okay, I'll ask Mr. Pucci, is there any chance that we could get some or all of those letters in a record request? Would that be within the ability of the town to find those letters?
I can agree to follow up, first of all, with the witness to see if she has either, if she's in possession of them or knows where we could request them. I'm happy to produce anything in our possession, custody, or control. It's just offhand, I don't know if, if we have them or who would be able to produce them to me.
Okay, so why don't we just make, I'm sorry, Ms. McDonald, were you about to say something?
Yeah, just Nicole McDonald. I would just say during the land court, I don't recall ever seeing those, and I have a recollection that at some point somebody had expressed some concerns about producing the letters with the information about the minor children. I believe there was a reference that some of them may talk about some medical issues, and so because they're minor children, I would just put that out there. I don't know the ins and outs of it, but I have a recollection that the town was protective of that information because they are minor children.
Okay, well then, why don't I make a record request, and just to the extent you can do a record request of the town, and that it would be for copies of the letters written by children to any town board or official complaining that they can't sleep at night because of the noise, and feel free to redact any personal information that is medical information, or even if you want to redact the names of the children so that they can't be identified, that's fine. But I'd like to see copies of those letters if you have them. I think that they would be useful to have in the record, in the record. Let me ask Mr. Brock, is this number 30?
No, it's 27.
27, I'm glad. Okay, so that's record request RR-EFSB-27.
And to Mark.
It's
I'm just having my cohort here take detailed notes about all the places that we're gonna seek those, so I'm sorry if I got picked up on the mic, that was me.
I understand if it is difficult for you to produce those
Oh,
letters.
no, it's not. We will do a complete search, and as I said, anything in the town's reasonable possession, custody, or control, I will see what, if anything exists, and I'll give a full response to the record request, either producing them or, as you said, producing a redacted version, or indicating that, the extent of the search and, whether or not anything was obtained.
I would be very grateful. Thank you. I appreciate that. It's 10 minutes after 1. Can we break for an hour for lunch? Does anyone object to that? Why don't I see you back here at 10 minutes after 2 then? Thank you very much.
Mr. Shea.
Yes.
Before we go back on the record, I wanted to let you know that Kelly Smith had to leave, so she is not here. I don't know, to the extent that there were questions that were going to be directed at her, we could reserve those till August 7th. We do have Tim Ryer, Kelsey Perry, and Kathleen Freeman here still. And so they could try to answer some of the questions if that would be helpful.
Thank you. I just have, before we go into questioning, I've got a short, holy smokes, what happened?
Oh, there I am.
Let's see.
What do you?
Somehow you all disappeared, but you're back. I just have a short, something I want to put on the record. And then we'll go off the record and see if there's anything else. But let's go on the record for a second, Mr. Brock. During the break, we had a conversation, and I'm going to withdraw that last record request because we don't really need a copy of the actual letters that the students sent to the town boards. Just the fact that, just the testimony that such letters were sent, that's sufficient enough for that's the limit of the relevant evidence. The actual letters, the record is quite voluminous as it is. We don't need the actual letters. So we're going to withdraw the record request that was designated as RR EFSB-27. Thank you for that. Let's go off the record. Does anyone have any matters they want to raise this time? All right, not seeing any, we'll go back on the record. I've got
Mr. Shea, excuse us. I think we had, if we could go back off the record, if you could.
off the record, okay.
I think, can you hear us? So I believe Miss Divakar had some questions that would have required Miss Smith to answer. So I think we've decided to take most of those questions and ask them on August 7th. Just to make that clear. If that's okay.
Good, thank you.
However, there are some record requests that I'd like to place, and I think I can do it even when in Ms. Smith's absence. So I'd go ahead with that, but keep the questions for later.
And I had just to preview what I have. I had some questions to follow up. I think I might save most of them for the 7th, but I do have some questions since Miss Perry is here today. I asked those questions today, and maybe some follow up, but otherwise I think the bulk of our questions might just be more suited for August 7th. Does that make sense?
That makes sense. I just have I'm just going to be pretty brief. Does anyone else have anything to raise before we go back on the record? Okay, Mr. Brock, let's go back on the record. I have some questions for Mr. Turner. Is he present?
Yes, I am.
Mr. Turner, thank you. So you remember the testimony that you submitted on behalf of the town of Somerset, dated June 5th, 2023?
Yes, I do.
Okay, and you have attached to that a letter as Exhibit A dated May 1, 2023 from the Town of Somerset Zoning Board of Appeals to Mark Bellucci, the town administrator.
Thanks a lot, sorry.
I'm sorry?
That was me, I apologize. I was talking to my associate.
But do you recognize that letter?
Yes, I do.
Okay, in that letter, the Zoning Board of Appeals, is it fair to say they have some complaints about the company's failure to contact them?
Yeah, I'd say that's fair.
Okay. But we've had testimony in this proceeding so before that the company was instructed to deal just with the town administrator. So I'm a little puzzled. Can you enlighten me as to what happened here?
I don't think I understand your question.
Okay.
Could you rephrase it, please?
Sure. Did someone make a mistake
Regarding what, sir?
Okay. Was it a failure when the company did not contact the zoning board of appeals? Was that a mistake?
I can't speak for the zoning board of appeals. I know the chairman is, he's the same with everybody.
Well, the letter is pretty negative. Would you agree that the letter is pretty negative about the company and its alleged failure to contact the zoning board? Is that a fair characterization?
I would say yes.
Okay. Do you know whether the zoning board of appeals was aware that the company had been instructed just to contact Mr. Alucci?
I do not know.
Do you know why the letter was sent to Mr. Alucci and not to someone else?
I don't know.
I beg your pardon?
I said I don't know.
No, someone else said something.
Oh.
All right, whatever. So.
Getting some background noise.
There's background noise, yeah.
We're closing the door.
I apologize. I just closed the door. I think that's from outside the conference room.
Okay, very good. Thank you. I appreciate that. So how did you get a hold of this letter, Mr. Turner?
This letter was presented to me by town council.
It was presented to you by town council.
Town council, you mean Pucci, do you think?
Yes, Attorney Pucci.
Okay. And did you have any communications about this letter with any of the members of the zoning board of appeals?
No, I did not.
Curious, do you know why you submitted this letter? You're not the author of the letter, is that correct?
Correct.
And you're not the recipient of the letter, correct?
I'm sorry?
You're not the recipient of the letter?
No.
Okay, so can you tell me why you submitted the letter?
We thought that it was appropriate, the letter, and based on my, added along with my testimony. Like I said, I think that the letter speaks for itself.
Yes, it does, but I was in court. Yeah.
Mr. Shea,
Yes.
it's Attorney Pucci. Sorry, I would never object to one of your questions, but we are getting into attorney-client, and as I had specified earlier, it was my call about what town agent would be most appropriate, somebody with most knowledge and access to town files. And I selected Mr. Turner as an agent to testify on behalf of the town because he's the conservation agent and health agent, and the town doesn't have a town planner or a zoning administrator that I could use as a witness to bring it in. And as I said to you before, I do not use volunteer board members as witnesses in evidentiary proceedings. So, and the other thing is about it is, it assumes the truth of the claim that the zoning board was allegedly not contacted because of some type of instruction from the town administrator. And that was why I, went through some of the questioning that I did yesterday to probe the
Let me stop you there. It assumes the truth of the claim. What assumes the truth of what claim?
Asking if there was a mistake about SouthCoast Wind not contacting the zoning board assumes the truth that SouthCoast Wind was somehow instructed by the town administrator that those communications had to go through him, and that they in fact made a request to him to meet with the zoning board. And that was why I asked 6 Ways to Sunday yesterday, do they have anything in writing confirming that, any type of verification that that effort was made? So to ask Mr. Turner about it, who's just basically testifying to the zoning board letter as a custodian of town records, I think is a little bit unfair.
So he's just here as a custodian of town records, is that right?
No, he has knowledge related to, permitting issues as the conservation and health agent. The Board of Health has jurisdiction over the noise bylaw, issues like that. He's a town agent with relevant knowledge and experience related to this case. But I'm also trying to streamline our efforts about how many witnesses we've produced. So I'm trying to produce a witness who both has relevant personal knowledge and also who can serve to verify, okay, here's a letter from the town's files, here's this or that. So I'm using him for many of those purposes. But I feel like your questions are sort of assuming the truth of South Coast Wind, saying that they didn't contact the zoning board or make an effort to contact the zoning board through the town administrator, and asking Mr. Turner about it, and he knows nothing about that. I'll bring in the town administrator. I'll bring in the town administrator, I'll voluntarily add him as a witness.
You won't do that today. Then I won't ask attorney-client privilege questions of Mr. Turner, of course, but let me ask you, what probative value does this letter have? Because it's not submitted by the person who wrote the letter, and it's not submitted by the person who received the letter, and the person who it's submitted through, Mr. Turner, is not able to answer any questions, as far as I can determine, under cross-examination, because he has no personal knowledge, and to the extent he has hearsay knowledge, it came through you, and you're asserting attorney-client privilege. So what's the probative value of this letter?
He's just confirming that this is a letter from the zoning board.
Yes, but what's the probative value of the letter? Why is it relevant? Why should it be part of the record? Why should I not strike this from the record?
Because it's the zoning board's position on zoning exemptions, and that they had not been consulted on it. And it also provided a lot of helpful information guiding you through how the bylaw applies.
Well, this letter that you want to be part of the record is signed by Stephen Cadaret. Is that correct?
The chair of the zoning board.
Is that correct, sir?
Yes.
Okay. Is Stephen Cadaret available for cross-examination?
As I said to you before, no. Today,
no. I have no further questions. I have no further questions on this matter, Mr.
Shea, I'm going to move to strike that letter.
Mr. Runge?
Yes, I'm going to move to strike the letter. It has no probative value, as you have just indicated, and it should not be included.
Well, what do you say, Mr. Pucci?
First of all, that's not correct.
Why? Why is it not correct? What's your reasoning?
Because it's confirmed as a letter from the zoning board by a town agent who has personal knowledge of that. And when was the objection raised to this? Before now? And my comments were just a respectful suggestion to you that inquiring to Mr. Turner about things that necessarily pass on the veracity of South Coast Wind's claim that they somehow were precluded from following up with the zoning board because of the actions of the town administrator is where this first came up. Nobody has raised an objection to the zoning board letter before. And as I said to you before, I do not call volunteer board members as witnesses in proceedings. They're possibly going to sit as an adjudicatory decision maker on any application with regard to this. It's commonly accepted that they're not appropriate people to bring in to testify.
Mr. Pucci, I understand your point. Let me ask you, under the Administrative Procedures Act, is there a right of cross-examination?
Absolutely.
There is, okay. Doesn't seem to be any doubt about that. Now, I think that having this letter in the record, the letter is a piece of evidence which is not there's no person present now for whom to whom I can address cross-examination questions. The author of the letter isn't present. The recipient of the letter isn't present. Any of the other people who may have been present when this decision was made to write this letter weren't present. You don't want me to ask Mr. Turner questions about things that you decided with him, that you as counsel for the town, you assert the attorney-client privilege. So if there's a cross-examination right, isn't that right being violated now?
I mean, I could offer to waive attorney-client privilege for your full cross-examination of Mr. Turner regarding the letter, but without waiver of any other attorney-client privilege. It also would have been nice, respectfully, to know before today that anyone objected to the admissibility of that letter.
Well, before today, to be fair, sir, before today, we didn't realize that Mr. Turner was not available for cross-examination as to a part of his own testimony. That struck me as a bit of a surprise.
If you're willing to do it this way, I would be willing to waive attorney-client privilege with regard to any of your questions related to the zoning board letter.
All right, why don't we see then, all right, why don't we just waive the attorney-client privilege for the limited purpose of questions regarding the zoning board letter. And Mr. Runge, your motion to strike is still pending. We haven't ruled on that. In fact, I can say I won't rule on that because that's the sort of major kind of ruling that we never do at the siting board. We never do with one person, the presiding officer. It's really a consultation among a group of people. And I only feel comfortable if I could consult with other people.
That's fine. That's fine as long as the motion remains on the table.
The motion's on the table, sir. Yes. Mr. Turner.
Yeah. Yes.
Let me ask you again, why are you the person submitting this letter into evidence?
And in consulting with Attorney Pucci, we thought it was appropriate to include it in my testimony.
Okay. Do you have any firsthand knowledge about the facts asserted in this letter, specifically the alleged failure of the company to consult with the Zoning Board of Appeals?
No.
Do you have any hearsay knowledge about those facts? Other than what you would gain from reading the letter?
It would only be what I gained from reading it.
Okay, I've got no more further questions. Mr. Runge, do you want to address your, do you have anything else to say on your motion to strike?
I think we've covered it. Again, we do not have either the author or the recipient present. And as such, the letter has no probative value and should be stricken from the record.
Okay. All right, well, like I said, yeah, Mr. Pucci, go ahead.
I'd like to respond on the record. First of all, if we're going to get into evidentiary issues and we're going to start tightly applying rules of evidence, the zoning board letter is a public document. And it was confirmed by a town agent. And a public document is admissible as an exception to the hearsay rule. So if this was a court of law, that letter would come in after it was properly authenticated by a town agent who has the ability to testify that it is a true and accurate copy of a letter sent from the zoning board to the town administrator, which I certainly think Mr. Turner will be able to confirm. Having said that, once we establish that letter comes into evidence as an exception to the hearsay rule. It is not hearsay. And then it is accepted into evidence, and you can give it whatever weight or not weight that you decide to give it. But it's certainly not irrelevant, and it is not inadmissible as hearsay.
Well, I don't think anyone ever said it was inadmissible as hearsay. I think the reason for striking the letter, if we were to strike the letter, would be that the Administrative Procedure Act gives the board and the parties right to cross-examine witnesses regarding evidence. And yes, it's a public record. but there's no one here to cross-examine about it. We don't have the author, we don't have the recipient, we don't have anyone with firsthand knowledge or hearsay knowledge regarding the allegations made therein. And so there's a question whether it's, you know, the probative value, the evidence. There's another question, which an evidentiary objection that you often hear is that the prejudicial effect exceeds the probative value. I mean, here there are all these allegations, which I regard as serious allegations, and yet there's no one here to be cross-examined about them. Tell me why we shouldn't apply the rule that the prejudicial value will exceed the probative effect.
What is prejudicial about it? The fact that it refutes the claim that they've made to try to support their zoning exemption in that they reached out to the local board and they sought a dialogue related to that? That's not unfair prejudice. That's evidence against SouthCoast Wind's claim.
Well, what's prejudicial is that the Zoning Board of Appeals is complaining that the company did not contact it. And there's no way to determine from looking at this letter whether the company was under obligation to contact the Zoning Board of Appeals or whether it was under an obligation just to deal with Mark Gallucci, the town administrator. So we have no way of determining the merit of these allegations. It's true, the allegations themselves, they are part of a public record, but the Administrative Procedure Act gives us a right to cross-examination, which I think is being violated here because there's no one to address the merit of these allegations.
Well,
and like I said, I'm not going to rule on Mr. Bunge's motion. But anyway.
I appreciate that. I appreciate that. But once an exception to the hearsay rule is provided and the document's authenticated, it comes into evidence. So the fact that you can't cross-examine the actual author of the letter, that's not a valid reason for then excluding it from evidence. If you ordered me to bring in the zoning board chair, I would do that. If you ordered me to bring in the town administrator, I would do that.
Why don't you do that? Bring in the zoning board
perhaps, Mr. Shea, perhaps we could take this motion under advisement and maybe some offline discussion on the best way to handle this particular matter, because we've had some good argument from both sides here, and perhaps we take it under advisement and then we can determine what we're going to do with this particular piece of evidence.
Very well, but I do want to just get one thing on the record. Mr. Pucci, if we requested that you produce Mr. Cadaret, you would produce him?
Yes, I would.
And if we requested that you produce Mr. Gallucci, you would produce him?
Yes.
What if the company made those requests?
Yes, I would agree to produce them.
All right, that's very helpful. Thank you. I've got no further questions.
Mr. Presiding Officer, I'm yelling across the room, and I apologize if the tone of my voice is obnoxious. I don't have my wife here to tell me to tone it down. So if I'm appearing disrespectful, I'm not. It's just I have a client to represent, and I'm trying to learn how to use remote means to communicate to you. So if I sound disrespectful, that's 100% opposite to what I am. I am 100% respectful of you and Attorney Runge and the whole panel of witnesses. So I just wanted to clarify that.
Thank you. I don't think you've been disrespectful, and I apologize if I might have seemed disrespectful. Just like I've been a lawyer for almost 40 years, and I did 21 years mostly in state superior court and sometimes in bankruptcy court. And it's a rough and tumble there. It's much more rough and tumble in superior court than it is. You're nodding. I think you agree. It's much more rough and tumble in superior court than it is here. So you develop a thick skin. I think to be a litigator, you have to have a thick skin. So I don't think I hope no one's thick skin has been pierced during our discussion.
Well, thank you, sir.
Thank you, my friend. I appreciate that. So I don't have any more questions of Mr. Turner. Thank you. Does anyone else want to question any of the witnesses? Anyone from the siting board?
I have a few follow-up questions. I could go now or follow my colleagues. Okay, I see Joan nodding her head. So I guess I'll take that as an affirmation. So let's see, these questions are for Mr. Turner in particular. And looking at your testimony, I believe on page 3, although the document is not numbered, but it is in fact the 3rd page, you list a number of areas of concern about impacts to the town residents. Is that correct, Mr. Turner?
Yes, sir.
And am I correct in understanding that the town's position and your position in support of the town is that the recommendation is that the siting board reject the company's request for zoning exemptions? Is that correct?
Yes, sir.
And does that recommendation reflect the town's view that it can adequately safeguard its residents from these types of impacts that you identify on page 3, given its own authority, if left intact and not exempted?
Yes, sir.
So are you looking for the siting board to further mitigate these impacts above and beyond what the town can apparently do under its own existing authority?
I would ask the siting board to consider them, but I have great faith in our zoning board, and I think that this could be handled at a local level.
So let me ask this. If the siting board were not to adopt your recommendation and did provide an exemption from the town's zoning ordinances, can you tell us whether the town has other forms of regulatory authority to address these impacts, again, outside of the zoning ordinances?
Well, I think for most of them, the Board of Health could probably have something to do with that.
And would that be an area of responsibility that falls under your purview?
I am not a member of the Board of Health. Our Board of Selectmen, they are the Board of Health as well. If there was any hearings, I would certainly be present.
Can you just tell us a little bit more about your specific roles and responsibilities for the town?
My specific roles is as the agent of the Board of Health and Conservation to make sure that any rules and regulations that we have are followed. Advisory role.
So these areas of concern would fall into your general scope of review and administrative responsibility, correct?
Yes, sir.
All right, well, if we could look at some of these particular concerns, again, that you've enumerated on page 3, I'd like to maybe get into some more specific detail on whether you see existing authority outside of the zoning ordinances for the town to regulate these types of impacts from the project. Are you with me?
I'm with you.
Okay, so let's just go through them one by one. The first one is regarding emissions or pollution that adversely affect the surrounding residential neighborhoods. Is that an impact that there is authority on the books for the town to address? Again, outside of zoning. Outside of zoning.
Outside of zoning, it's my job to protect the health and safety of our residents to the best of my efforts.
So if you saw or measured some type of air pollution being discharged at a construction site, such as the project in the future, what action would you be in a position to take?
Well, depending on what kind of pollution it is, and that would certainly be a factor as to how quickly I would respond. I would first approach somebody at the company to see if anything like this can be stopped. And if it couldn't be, well, then it would get into it would push me to issue a correction order or to bring in any other authority, be it EPA or DEP.
So if I'm trying to understand exactly where the rubber hits the road, is your authority more in terms of general enforcement, or do you also have a role in prescribing conditions or permit restrictions before the activity even commences?
Well, I know you keep saying outside of zoning. The first step would be if there were any. I mean, it's in the zoning bylaw as far as keeping everything on the site, the dust, the noise, etc. So outside of that, I would be more of a response than anything premature. It would have to happen.
So it's reactive, not proactive.
Correct. I could not get the words out. Yes.
I was just channeling what you were thinking.
Thank you.
So would the general, description of your function be sort of dealing with nuisance issues or generalized threats to public health, safety, and welfare?
Both.
All right, let's keep going. So the next point we covered somewhat earlier, which is excessive noise that violates the town's noise control bylaw. And you do clarify that it's specifically the general bylaw, not the zoning bylaw. So it seems clear that there is separate standing authority for the town to address noise.
Yes.
Okay, what about lighting and shielding residents from light pollution?
That would be a reactive response as well.
How about dust or particulate matter that might be emitted?
Well, outside of that already being in the zoning bylaw, if there was any generation of dust, and again, it would be reactive, I would go and investigate it and try to determine the source and see if we can make it stop.
How about wear and tear on town roadways and maintenance?
Well, we certainly don't want our roads becoming unsafe because of truck traffic or heavy machinery or anything going down there. And again, it's a safety issue with the amount of traffic and the people that live on that road.
And is that part of your responsibilities, or would that fall into a different department?
Well, it could perhaps fall into a different department, but I would want to keep my eyes on the whole thing, the whole picture.
And how about contaminated waste on site and abatement?
I would want to see what they were going to do as far as any existing contaminated site, and I want to know what their plan was to have it either removed or reused or etc.
What about the question of whether the soils coming on the site are clean, are certified as clean?
We don't want any recycled soils coming in. If they have to bring in any fill, we want it to be clean fill.
So again, that's an area that you could potentially enforce as part of your non-zoning authority.
I believe I could.
And I assume that that answer extends to the next bullet in terms of construction management details needed to address contaminated soils and how to prevent those contaminants from becoming airborne or released into surrounding water?
Yes, sir.
And the same for the next bullet on potential releases from hazardous releases from excavation or construction activities.
Yes, sir.
And finally, stormwater management.
Yes, sir. That's my role as conservation agent.
Okay. So it seems like you have very broad areas of responsibility and enforcement authority that do not strictly rely on the zoning ordinances of the town.
Yes, sir.
Okay. General question with regard to these kinds of impacts that we've been discussing. Are there clearly defined thresholds that you have, you refer to, you rely on in addressing each of these concerns in terms of deciding whether a company's activities are permissible or impermissible?
You reword that, maybe?
Yeah. I'm looking to understand if you have, sort of bright line criteria that define acceptable practices such as emissions, stormwater, dust, noise, or whether it's more subjective in your personal assessment of, I smell an odor, this looks like light pollution to me. Is it an subjective application of your responsibilities, or are there numerical, clear, delineated thresholds?
No, initially it would be subjective until we investigated it.
And are you required to produce some form of measurement to take enforcement action?
Yes, I would.
I wanted to look a little bit more deeply into one of the particular areas, which is noise. Again, something we talked about earlier this morning. And my understanding of the noise ordinance, again, I'm not talking about the zoning ordinance, indicates that between the hours of 7 a.m. and 10 p.m. at residential properties at the property line, there is a limitation of 65 decibels. And over 65 decibels would constitute, I suppose, a violation of that ordinance. Is that?
Well, if I got a complaint and I needed to go out and investigate, we have the equipment. At that point, I would determine if it was over 65 because a motorcycle went by. That's a big difference than it being over 65 if somebody's playing loud music all day long, or etc.
Can you sort of give a more precise, maybe legal definition of what distinguishes the motorcycle from the all-day party or what have you? What is the obviously the decibels don't care what the source is, but you do. So could you explain why?
Well, a motorcycle going by the house, even over 65 decibels, that is a 2-second ordeal. You've got somebody playing loud music or the noise of scrap metal loading a ship 24/7. And if that's a violation, if that is considered to be a violation, then that's how I would look at it.
Okay. Are you familiar with lawnmowers and the amount of noise they generate? And I'm talking about a gasoline-powered lawnmower, not an electric type of lawnmower.
Yes, I am.
Do you have a rough measure of what the kind of decibel level is produced by a typical residential use lawnmower?
If I were sitting in my house, and lawnmowers, they're exempt in the town bylaw. If I was sitting in my house from my own experience, if my neighbor was cutting his grass and he went right by an open window, that would probably be pushing 100 decibels. As it went to the other side of his house and he got further away from me, well, then it would go down quite a bit.
You said there's a specific exemption for lawnmowers in the town's noise ordinance. Is that what your testimony was?
Domestic mechanical equipment, the outdoor use of domestic mechanical equipment, such as but not limited to lawnmowers, leaf blowers, power saws, is permitted between the hours of 7 a.m., 10 p.m., Monday through Saturday, and on Sundays and legal holidays between 8 a.m. and 10 p.m.
Thank you. That's very helpful and very specific. Are there any other areas from your experience that sort of commonly come up in the, let's call it gray zone, where the noise may measure well above 65 dB, but the ordinance does not specifically prohibit that type of activity?
I couldn't speak to it unless there was a particular situation that was going on. And what was causing the noise, how much noise, how long the noise was lasting.
For residential construction activity that could involve power saws or grinders or things of that sort, where does that stand with respect to the noise ordinance?
Could you reword that? I don't think I understand the way you.
Yes, I'm trying to find out whether there are similar specific carve-outs in the noise ordinance for other types of residential equipment involved in construction, like power saws, sanders, grinders, and the like, jackhammers, what have you.
No, it says power saws in there. I think domestic mechanical equipment certainly describes, I think, what you're looking for.
Excuse me, this is Attorney Pucci. Can I just specify, because I'm not in the room, is Mr. Turner looking at the noise ordinance bylaw that's in evidence in this case? I just want to find
Yes, I am.
because he's looking down a lot in response to Mr. Green's questions. I just want to make sure we're all looking at the same document.
Yes, I am.
Thank you.
And I'll be clear also by saying that my recitation of the noise ordinance decibel level came from the company response to EFSB information request number 3-2 or NO 3 paren 2.
Is that the one you have there, Tim? Because that's what I'm using. Nicole, can you confirm that?
Mr. Chair, I know the question isn't to me, but just for the record, because we don't have access to the exhibits, it's a document titled Noise Control Bylaw, Article 34, ATM Annual Town Meeting, 5/17/2021, and it's a 8-page document.
Thank you.
So this question is not strictly from Mr. Turner. Any of the town witnesses, feel free to offer your perspectives. Frequently, when the board grants approvals for almost any type of activity, they generally come with conditions intended to promote public health, safety, and well-being of the public in conjunction with the project development and operation. And I do understand that I think all of the witnesses have recommended that the siting board not grant the zoning exemptions. That is the specific request I think we see in the testimony. And correct me if I'm misstating the perspectives of the witnesses. I'll just stop and see if anybody disagrees with what I said.
Nicole McDonald, where the residents and the town witnesses are asking that the siting board deny the request for the zoning board exemptions. You're absolutely correct on that.
it hypothetically, if the board were to grant the zoning exemptions that have been requested, are there specific conditions that the town's witnesses would recommend that the board adopt to ensure the protection of the town's residents and other interests of the town?
So Nicole McDonald, if I could, I'll start with that, and then I may ask Dr. Healy to weigh in on this. I don't want to, just speaking for myself, I don't want it to seem as though the town wants to not have the protections that the siting board can put in place. And again, I'm not an expert on these type of petitions or the siting board review. I heard very technical questions asked by the board, and obviously your board has an expertise and resources to put very comprehensive conditions on a project. I am asking that both take place so that there's the additional layer of protection. So in other words, whatever conditions the siting board feels is appropriate, because again, you have knowledge as to these large scale projects that I certainly don't have, and perhaps the town doesn't have, but we're asking for that additional, when it gets into the actual town, allow our zoning board to review it. And whether the zoning board simply incorporates the siting board's conditions, it then becomes a local zoning board decision that our building inspector can enforce on the local level. So it's two layers of protection. I'm not asking that it just be given to the town and, say the town's the first and last line of defense. I think there should be multiple levels of review, which is the way the system is set up. There are state and federal guidelines, Mass DEP, EPA, the siting board, but we're also asking that the town zoning board be allowed to, if there's something that is specific and unique to Somerset, give the zoning board the ability to put that into a condition in a decision that then we can have enforcement. And the way the town is set up, the zoning board, if there's an application for a plan development, the zoning board can put specific requirements in there. If there is a violation of that, then the building inspector, as the zoning enforcement agent, would enforce that. The zoning board would then have the authority to issue a cease and desist or any other orders they deem appropriate. If there is an issue or a further dispute, then it becomes an appeal to either the Massachusetts Land Court or the Superior Court under Chapter 40A. The town does have the noise ordinance on the noise issue, but again, when you read through the noise ordinance, the enforcement powers are somewhat limited. So we would like, I would ask, to have both, so that you could have enforcement under the noise ordinance, but also have those protections under 40A through zoning, such as we went through with the scrap metal. The scrap metal operation continued to operate up until a Massachusetts Land Court judge finally issued an order to cease the operation, and then and only then was the operation discontinued. So we're asking for all the layers of protection to be put in there. And for Somerset, in addition to zoning, we do have stormwater regulations that would go through the planning board. We have conservation would be enforcing the Wetlands Protection Act. And I believe I heard in the testimony, the petitioner is still going to be coming before the conservation board. We have Board of Health to address, general issues. So the town is structured to give those protections to the residents. I would encourage, and this board has a level of knowledge that the town doesn't, because this is a large scale project. So I would ask for both. I'd ask for conditions from the siting board, but also give the local town its ability, if there's anything additional, specific, minor in the terms of the siting board, it might be minor to the siting board, but very critical to the town. So that's, and I would ask Dr. Healy, in terms of conditions, I know there was talk about, giving the town, this is going to be, the construction is proposed to be 2 to 3 years, and then you get to the operation. The site itself with 300 acres, SouthCoast Wind is 10 acres, Prismium is 47. You have an additional 240 plus acres that are potentially going to be developed. The Prismium project is potentially 7 years of construction. So you're going to have two large scale projects being constructed at the same time. And we're not talking about, a 4-month build or a 6-month build. This is years. So the talk or the request, and Attorney Pucci had raised this yesterday, a licensed site professional that is financed or funded by the petitioner, but is protecting the town and giving the feedback to the town, an industrial hygienist, some ways that we can test, monitor, and continue to make sure that the residents are protected and that the contamination isn't exceeding the property. And the last thing I'll say in terms of the contaminants coming off the site, Somerset is about 7 miles end to end, the entire town. So the questions to Dr. Healy saying he doesn't live in that neighborhood. Being on the coastline, contaminants from that site aren't just blowing to my house or Ms. Thomas's house. They land on my house, and then the next storm they blow onto the next resident. So that geographical area of 7 square miles, it's not a large area. So activities at that site have the potential to affect all of the town of Somerset, as well as Fall River, which is within visual distance across the river, and Swansea, which is on the other side. And with that, I'll defer to I'll yield the floor if Dr. Healy wanted to add to that.
Yes, thank you. Can you hear me okay? This is Paul Healy.
Yeah, Mr. Healy, before you respond, I just want to emphasize a part of my question, which was touched on lightly in that last response, but I do want to get more understanding, which is what proposed conditions might the witnesses offer in the event that the board grants the zoning exemption request?
I could answer that myself. It's Patrick McDonald. I would like that the converter station is built in a building that shields the electromagnetic fields from the neighborhood and shields the noise. That was the original proposal. I think that it should be in a building, that it shouldn't be left outside with a fence and kids that can hop the fence and get themselves into big trouble. I think that with the amount of megawatts of electricity that they ultimately proposed there, why not let's do it right the first time and not be complaining to the governor's office or the energy secretary that this outdoor monstrosity is horrible? Why can't we just have it in a building that has all the noise reduction, that has some shielding from the electric magnetic fields? I also feel, again, strongly that the shortest horizontal direct drilling to the converter station be the route and not the proposed route that they're taking, and that none of that drilling occur on Sundays and at night, because that just it's going to be an abomination for the neighborhood to listen to 100 decibels for that period of time. And I think the route that they want is not necessary. I don't know why they're choosing that route through the activity use limitation area. It makes absolutely no sense to the maintenance of that cable if something goes wrong to get to it. I think that, we don't do it anywhere else. We put all our utilities in the street and are accessible. This utility line, they want to put it under sludge and contaminated landfills that are controlled by DEP. I just don't see that to be necessary, and I would really want the building, that the converter station to be in a building, so it's locked away from the residents. That would contain all its dust, all its noise, and shield us from the magnetic fields. I think that would be a big help to the residents. I think the residents would rather have that than something that's buzzing outdoors 24 hours a day, 7 days a week for their entire lives. And you got to remember, the health and safety of the residents is first and foremost in our zoning bylaws, and I hope that it's also with your consideration and what you want to do with this project. Thank you very much.
Mr. McDonald, you mentioned a while ago, I think this morning, that when you first saw schematic or drawings of the converter station building, that I think you said Ambaric
Yes.
may have provided before Mayflower and South Coast Wind were involved in the project specifically. You actually likened those drawings to some building in Australia. I forgot which one you were mentioning.
The Opera House in Sydney, Australia, right on the harbor. It's that famous white building that you see with the multifaceted peaks to it. It almost looked like that. It almost looked like, hey, I'm going to age myself. Remember the Great Gazoo, the cartoon? It looked like the Great Gazoo's helmet. So it was something to that level, and it looked really nice. And you looked at those renderings, and that was at the time that they said, this is going to be green energy. They said to us in the neighborhood, this is going to be your opportunity to live hand in hand with green energy and clean industrial uses and neighbors living side by side. And it was a very kumbaya come to loving moment. And it's deviated from that. And I think we want to get back to that kumbaya moment that we can all be happy and live together as neighbors down there. Hear us and work with us, because we're not trying to throw them out. We're trying to say, live with us, sleep with us. The power plant, I used to say that all the time. The power plant slept with us, right? So let's all sleep together and not have that person that's constantly kicking you in the side in bed and waking you up, right? Nobody wants that. So that's what I'd say it's akin to, is a good camping neighbor.
That's a very colorful metaphor. Thank you for sharing that. So the reason I actually asked about the Australian reference is not because I'm planning a vacation, but because, a building to one person can be the Australian Opera House, and to others it might look more like a penitentiary. So I'm just wondering whether aesthetics are really an important part of what you're recommending in terms of, quote, putting it in a building.
So aesthetics aren't so important, but who wants to look at something that looks like the DDU in Walpole, the disciplinary detention unit? It's like, you don't want to look like a prison. It would be nice that they make it a little aesthetically nice, but I'm not asking them to spend millions of dollars to make it an art piece. But they did kind of make it look like an art piece, and it was pretty wild that, hey, that's going to be near us, and there was actually two of them side by side. So maybe it was originally supposed to be 2,400 megawatts, and it was going to be two of those converter stations.
Okay. Let me ask that, this is again an interesting point. I'm wondering if the question was ever asked of South Coast Wind, why the converter station now, and I'm taking your testimony as true, appears different than what was originally presented by Ambaric, and what the reason for the change might be. Any of the witnesses can respond to that? The town witnesses.
So,
Go ahead. Could you repeat the question? Sorry.
Yeah, I'm just, again.
I'm sorry. What was your name?
Kathleen Souza.
Thank you.
Right. My question is whether any of the witnesses have asked the question or otherwise received information from South Coast as to why the design of the converter station has apparently shifted from what was previously presented by Ambaric.
I have not received any information on that, to my knowledge, other than, I know there's been significant changes right along between whether it's companies changing to who's coming, to name changes of the company that's coming.
So Nicole McDonald, the rendering, it was just that. So nobody's saying it was, definitive drawings, but the rendering was, the whole property was covered with, staging ground for wind turbine blades, the converter stations, solar panels, a green energy education center. So we're not saying that was, we weren't going to hold anyone to that, but it's the concept that we've always been shown renderings that are, it's a capped facility. It's not just a big, if anyone watched the videos of President Biden visiting Brayton Point, there was a reference in one of the news commentaries that the place looks like, Mad Max Thunderdome. So we're just trying to get back to that point where I don't think anyone's looking at necessarily aesthetics. We've been just fighting for clean air, clean water to sleep at night. But to Patrick's point, having it be in a building, and I'll just, so we never got an answer to that. Truthfully, I haven't asked. I don't know that anyone's ever asked. We've been busy just focusing on the health aspects of it.
If I may, Kathleen Souza again, if I may, if you put in wind energy in Brayton Point, just in Google, it'll come up with this beautiful picture of the rendering of what was supposed to be next door to us, our neighbor. It was going to be, and it shows the picture right there. And it says solar power, HVDC converter station, energy education center, offshore maintenance dock, offshore turbine foundations, offshore wind components laydown area, energy related manufacturing, battery storage. I mean, it looks beautiful. It looks like something you'd want to live next to. And then suddenly now we have just an outdoor standing. Yes, that's a photo.
If I could show you, can you see that?
I'm sorry, who's speaking?
Patrick McDonald.
Thank you.
So I'm just bringing up the rendering.
Yeah, I actually, since apparently it is available online and that's where you're getting this image from, could I make that a record request that you provide either an image of what you're looking at right now, or at least provide the website address so that we can access that image?
Absolutely.
Mr. Shea, can we make that a record request?
We certainly can. I'm gonna ask that it be made record request RR EFSB-28. We made 27, but then we withdrew it, but I don't want there to be any confusion. So, Mr. Brock, can you identify this as RR EFSB-28?
And
I'm sorry, is that a question to me?
Yeah, is it all right with you to designate EFSB-28? That's not, because we had 27, this is off the record. We had 27, but we withdrew it, so I don't want there to be any.
Yeah, there's no problem. It's very clear.
Okay, all right.
I got lost though. I got lost. Was this just the same thing requested earlier? The sketch on Mr. McDonald?
I don't think so.
I'm sorry.
I'm asking for the image that Mr. McDonald was just showing us on his phone, I believe.
Yes.
And I was going to ask for just a little bit of understanding if that was an image produced by Ann Barrick or Mayflower.
I just got confused as to what we were talking about. Thank you. You've clarified. Thank you.
That image was Ann Barrick. That's Patrick McDonald, please.
Okay. All right. Just want to make sure we get what we ask for when the record request is provided. Thank you. So we were on the general topic of, again, recommendations from the panel for any conditions that they would want the board to impose if it grants the zoning exemptions. And Mr. McDonald gave us a pretty good rundown of several of those recommendations. And again, I'd like to hear from any other witnesses of the town on your recommendations.
I think Mr. Healy wanted to speak. He's in a different room.
Yes, this is Paul Healy. Thank you for the question. So I think of this as an issue that still needs to have further risk characterization. And what I mean by that, specifically to the noise elements of this, is we need to understand the noises. So where exactly during the construction phase will the barge or vessel be out to in the Lees River if it's done on that side of the landfall? And how close, if I assume it to be somewhere in the middle of the Lee River, maybe that puts it 250 feet closer to Swansea and away from some of the Brayton Point people. And it may also take it out of the direction of the berm that is a buffer to some degree. And the reason I'm trying to get to that specificity is we don't have that information, and that can be modeled. And I know that at least the operational aspects were modeled in the FEIR, and I'm just starting to go through that. But I think that there needs to be different models for these, and you can get the manufacturer's specifications specifically on each of these pieces of equipment and put that in there. And you can look at that, the octave patterns, the frequency over patterns that they have, and start to predict whether they're going to be violations of the noise bylaws, etc. And that can, you also need to look at the types of equipment that you're going to monitor the sound levels or anticipate monitoring them, specifically whether you're going to look for impulses, and that takes a shorter window of time. So a gunshot that happens, twice in an hour may not be picked up on certain pieces of equipment. So you need to have certain types of specific equipment to monitor that. Then there's also a recommendation that we consider in this modeling and assessment that we not only look at what I believe was done to look at ambient noise as baselines to compare to, was done in the winter. It should be done winter, and it should be done in the summer to get a better idea when there's no foliage on the trees, or when there is foliage, and the impact of that on local residents. Those are some elements around noise that we should get further information. I have some other points when if you have
Mr. Healy, I understand what you're suggesting, and just want to ask if you are aware of whether the company has performed any noise modeling of the project.
As I mentioned, I think in my just now was, I am aware that they did do some modeling with CADNA that was done, I believe, for the operational phase, not for the pre-construction and construction phases. And so I need to look at that. Now, it's missing stuff in my cursory review of their FEIR attachment, whatever, I forget it, whether it's B or M, something like that. There is a lack of information that incorporates all the different pieces of machinery that would be operating, and would they be violating the mass noise policy or the town's policy. And you could look for differences, whether there's an elevation above ambient noise at night and in the day of 10 decibels. Those types of things we would expect to be able to look at to see the impact over time. And in developing the ambient, I don't know exactly how many days they looked at, but in another proposal that we've looked at, they did it over a 4-day period to get a good baseline ambient amount of time. So these are things that I would be looking at to advise the town and critique the findings where it may have faults in the assumptions that they're doing. Now, again, I would do this in consultation. I'm not an industrial hygienist. I would do this in consultation with an industrial hygienist, but I have enough background to understand this from my training as an occupational and environmental medicine physician.
Are there any other conditions that you'd like to address? Again, assuming the board grants a zoning exemption.
Sure. I think that some other things on the risk characterization would be to understand the impact of any drilling or any type of construction activities on the the ash pits and the AOL as far as the linings. You can look back to 2009 when they replaced the covering with a geosynthetic, I believe, membrane over top of the 1A site, that they had lots of pictures in the record that you can see where those membranes were ripped, torn. And the concern is that when they do the HDD or they do any other type of construction, will they be tearing those over the 10 pits on the lee side of the river? Now, that would be assumption that there's some sort of seismic activity. Some of these things are, if you will, staked down, and they're going to likely rip, especially since they're old. When you go back to the membrane that was recently put on, I think it was in 2009, over the 1A, they stake that down. And you can look to see in the information that I've seen online that there was a 5-year warranty. We're now, 15 years out. I mean, somebody should be requesting that we assess those with ground radar to see if there's any tears, as to make sure that there is no penetration of water as it goes down. Okay.
Mr. Shea,
Yes, Mr. Ranj.
may I just make the point that I think it's already been clearly established that Mr. Healy is not an expert witness, and it sounds like he's offering testimony along the lines of what an expert witness might try to offer. And I realize he's answering questions from Mr. Green, but I just want to note that for the record.
Okay, so noted.
So I'd also suggest that there would want to be a assessment of any neighbors in the area that might have wells. I know, and I've done that check for at least the Somerset side, that there were a couple in the Brayton Point area, and that they have now transitioned to they get direct water from the town itself. But we don't know what's happening over on the side of Swansea specifically, and whether they use it for drinking water or they use it for their lawn care. And the reason I say that is we don't know if there's any contamination in those. And indeed, if any of those happen to be open, that may be something that the board may want to recommend, seeing if we can get samples from that to see if it's crossed the river, since that area is heavily contaminated.
Is the use of wells in Somerset for drinking water or for irrigation, lawn maintenance?
It's my understanding they've all been closed in Somerset.
So can I say something? This is Peter Pelletier. I still have a well. I have town drinking water, but in addition, I have a well that I never closed because of the cost of water. I used to use it for irrigation and for watering my animals. I have several animals, outdoor chickens and such. And but I did stop using it when we had trouble with soil contamination from all the dust that was coming into the neighborhood. I was in fear that the cyanides and the mercury and other toxic things would be exacerbated by giving my animals contaminated water when I was going to eat the eggs. It's bad enough that, I'm sure that the grass they're walking on also had that dust on it. But anyway, I personally still have a well, and I would be okay with testing it. I also know a few other people that actually have open wells. They have like a cement cap on top of them. And, and there's been talk in the past when we were having dry seasons of, dropping a sump pump in there and using that for watering grass and such. So some of them are not being currently used, but they still exist. And the people who own them have not ruled out the desire to use them. We just don't use them because of, everything being up in the air lately. So that's it. Thank you.
Kathleen Souza. I do have a neighbor who's still using a well. there are wells in Brayton Point, and I do know of one, at least one neighbor, if not two, behind me that are still using their well for drinking water, for showering.
Okay.
Nicole,
Mr. Healy is still testifying. I just wanted to note that.
okay.
Thank you. May I continue?
Yes, please.
Perfect. Thank you. So just to return back to the vibration issue, there are ways of monitoring the impact of these pieces of equipment and vibration. And one major issue that's open in my mind is we did have a tremendous seismic impact in that area when they tore down the water cooling towers. We don't know, and they're right around that area on either side of the RTN 413169, the 1A site. We don't know if that's had an impact on a, at that time, probably 10-year-old membrane with its warranty for 5 years. And I guess my question is, really, do we understand the risks in that area without further assessment of it? And then I guess lastly is we need this information to, as Ms. Smith has suggested very clearly, to start to think about engineering controls. But if you don't know what the risks are, you cannot mitigate them with engineering controls or administrative controls adequately. And then I think finally, one thing is in the soil sampling that is done, there is an importance to do not only the boring and the wells, but also to do the surface assessment. And you can see in the record of the evaluations of 169, the RTN 169, is that they also did spatula sampling of the top 1 or 2 inches of dirt there to try to, because this is what's going to be blowing around, whether that is contaminated. Now we know that a lot of this has been impacted by the tearing down of the cooling towers and the breaking up of that material and the mixing of all this. But since we're worried about dust that's contaminated blowing, we want to assess that as well. And I think that concludes unless people have questions. Thank you.
I'd like to take a break at an appropriate point because it's 3:30, but also I want to talk to the my colleagues on Teams during. Normally we take an afternoon break anyway. I'd like to have a short conversation to clear up some matters.
Sure. Mr. Shea, I don't know if we've heard from all of the town witnesses in response to my question, but even if we haven't, we could break now and hear from the rest of the witnesses later. But again, I don't know.
All right, why don't we break now? Mr. Pucci, you can consult with your witnesses, see if more of them want to talk about to this issue. And then
before you break, could I just note to the witnesses that I can't talk to them directly? We don't have a breakout room or anything. I think their answer to Mr. Green's great question was very thorough. They should think about it during the break. If anyone else has anything to add, they should do that after the break. But if not, they shouldn't feel the need to testify further on that. Is that fair?
I do want to maybe give a sort of prelude that I think, given the importance of the question and wanting to get as good an answer as possible and not just, extemporaneous thinking, that we may want to make this a record request to provide the fullest opportunity. So, but this is, again, to get an understanding of what the parameters may be for that response.
If you wanted to offer a record request, then I'll cancel the request that we all get together on Teams, because that's what I wanted to discuss, whether it would be better to do this by a record request.
I got your message telepathically. So, but yeah, that's where I'm going. So, but we could take a break and get back to the rest of the testimony and the record request.
Okay, so why don't we do a 15-minute break? And there's no need for us to go for the EFSB people to meet each other on Teams. 3:31. Let's meet back here at 3:46. Thank you. We're off the record. Everyone isn't on yet, but just ask Mr. Green, do you want to make a record request?
I do, but again, I want to just give the opportunity for oral testimony first to hear top of mind thoughts and then make a record request.
Okay, so we'll just resume your questioning. The town witnesses are back. Not all the company witnesses are back, but I don't know if they're all needed. Mr. Runge, do you object to us going forward now?
No, I do not object.
Okay. All right, then let's go back on the record. Mr. Green was questioning the town witnesses. Why don't we resume that?
Thank you. So again, just to refresh the pending question, it was for the town witnesses to provide any recommended conditions should the board grant the requested zoning exemption for the project. And we've heard from some of the witnesses, but not all. So I just want to hear any other recommendations.
I have something, Mr. Green. This is Nancy Thomas. So I have a couple of things that I'd like to see implemented. We didn't really touch on this, but I am a recreational kayaker, and our waterway is used fairly heavily for boating, fishing, kayaking, windsurfing. There's a sailing program close by. So my concern is that the laying of the cable, the installation of the cable, and the subsequent presence of the cable is going to restrict access to our shared waterway. And I'd like some kind of guarantee from the company that they're not going to restrict our access. Another issue are the diesel.
I'm sorry, could I just interrupt for a moment? There are several different waterways in the vicinity of Brayton Point. Could you be specific as to which one you're talking about?
I'd be talking about both, actually, the Lees River side and the Ripley Street side, as well as toward the Fall River area, the lighthouse, the Board and Light Marina area. I understand.
I'm sorry, the lighthouse and the what?
The Board and Light Marina area. So anything in the surrounding area, we call it the Mount Hope Bay or the Taunton River area. And it is heavily used by recreational, like I said, boaters, kayakers. There are fishermen there every single day. There's a sailing program nearby. So any interference of that cable to the recreational uses and access would be of a concern to us. And I'd like some kind of guarantee that they're not going to restrict that zone at all to the residents.
Okay. Anything else?
Yes, the dust, as I mentioned before, the dust is a huge concern, and I'd like some kind of condition put on them that it's going to be contained to their site when they're doing construction or laying cable or for any other activity, that no dust from that construction comes onto our properties, Lees River side or the Summit Brayton Point side. And one more, the diesel fumes. I understand there's going to be a lot of equipment used for this process, and we suffered through the diesel fumes with the ships before, and it's really a noxious kind of odor, enough that we had to call Board of Health and the fire department, and people suffered from headaches and sore throats. And I'd like some kind of guarantee or some kind of protection maybe offered to us that they will contain their diesel fumes, both offshore and onshore activities, to their site. I think that's pretty much what I would ask for.
Just, from a practical standpoint, obviously, if a piece of equipment burns diesel fuel in an engine, even with emission controls, the exhaust will go where the wind blows. So I'm not sure that, no emissions anywhere else other than on site is achievable by any modern piece of equipment. So short of putting a giant bag over the facility during construction, I'm not sure how that could be achieved. So I'm just looking to see if you have a sort of more practical formulation of that recommendation?
I'm not opposed to the giant bag, but I knew you were going to ask me that question. I wish I had the answer for it. I don't. I will leave that to the more engineering minds than mine. But whatever protection you could offer or suggest would be welcomed.
Hi, this is Paul Healy. Just a quick comment. One thing that we could talk about is whether they can do their operations using electrical power.
That's certainly within the realm of the possible, I'll say.
Kathleen Souza. One of the recommendation or requests that I would have is that there's conditions on the operation hours. So from the construction hours, to keep in mind that there are many children in our neighborhood and to have the hours limited. In the past, we've had truck traffic limited to 7:30 to 5 p.m. 7:30 to 7, I believe, but at 6 p.m. There is a sign up currently, but the operations for construction, and I would just ask you to consider your own families in your residential neighborhoods. What's a fair time that, homework is starting, dinner time is starting, and with the noise, could we have hours set to reasonable limits? 7 a.m. to when the kids are getting up for school until, either 5 p.m. or 7 p.m. when kids are starting to go to bed in homework time.
Yes, Tim Turner. I would just reiterate the bullet points in my testimony that we discussed earlier, rather than go through that whole page again. I'd like to see as much of that included as practical or possible.
This is Pete Pelletier. On the subject of, I like the idea of electric running the power, running equipment, as opposed to diesel generators making electric to run the equipment. But if you do have to use diesel, there is low sulfur diesel that is a little better. So I would recommend that anything that has no ability to, that anything that has to use diesel be required to use low sulfur diesel. In addition to that, I would ask that we could have a clear path for issues. When we have an issue, sometimes it's just a quick issue. Like, let's say there is a heavy smell and we would like somebody to look into it, and maybe they can turn off a piece of equipment they're not using or is not needed today or whatever. So if there's some kind of a clear path, someplace that we can call to report these issues and maybe get somebody to look into them and correct them in real time, that would be that would be really important. If I report that I've got to close all my windows on a 90-degree day because my house is getting filled with diesel fumes, it's not so helpful if the problem is solved 2 weeks later. It's nice if I can get a hold of some kind of an on-site person or somebody who's responsible who can get a hold of an on-site person and get something fixed in real time, or at least get a response back saying this is what it is and this is how long it's going to last, or whatever. Just real time, somebody to talk to in real time, a real person, and some of the simple things that could be fixed easily will go a long way. So anyway, thank you.
And Nicole McDonald, if I could, I'm not going to duplicate anything that was just mentioned, but to add on to that, the stormwater was raised in one of the earlier days of testimony, and I believe the representation was that SouthCoast Wind's stormwater will go into Brayton Point LLC's stormwater. I don't believe there is any actual stormwater system in place, and we've had issues. The Attorney General's office had issues with not complying with the Clean Water Act. So I guess protection that it's not let's just put it into Brayton Point LLC's stormwater system that may not exist, and then Brayton Point LLC is just pumping it directly into the bay. I think it needs to be looked at again because of the contaminated nature of the facility. And the last two things, to the extent there can be monitoring during the construction, and I don't know the details of how that would work, but that falls under the LSP, the industrial hygienist. If there can be some, that this isn't just an approval and then we're sort of sent off, some monitoring so that we have some ability to check and ensure that the conditions are being complied with. And the very last thing, there's one road that leads to that facility. And there was a report that was done in 2018 on behalf of the town to assess the condition of the roadway. And at that point, the condition of the roadway was already in a pretty deteriorated state. So if there could be any type of an assessment as to the current status of the roadway and what the roadway is projected to be in terms of condition post-construction, and if there can be some contribution towards repairing or repaving. I guess the concern is that roadway's already in tough shape, and following 3 years of heavy construction, we just have a concern what the condition will be at that point.
With regard to the monitoring that you were just mentioning, is that monitoring by independent personnel under the direction of the town, or are you expecting the siting board to do this monitoring or some other entity?
I'm going to defer to the expertise of the siting board members, but I think at the town level, the town's ability to retain an LSP and an industrial hygienist to do testing as needed. So to give you an example with the scrap metal, a condition of that permit was that the petitioner put funds into an account managed by the town. The town could then use that money to, if they wanted to do a round of testing or monitoring, they could use that money in that account. So again, I'm not necessarily sure exactly what I'm looking for, other than I'm looking to not have that burden be shifted onto the residents. So, if the town feels that there's concerns about contaminants coming off the site, the town could either have an LSP, overseeing the site, or an industrial hygienist, or the ability to do some swipe samples in the neighborhood that can confirm that we're not having contaminants coming into the neighborhood. So I'm open to any suggestions. I don't know how the siting board has handled this in past projects, but just something that's it's not gonna just be, here you go, have at it. So something that we can have checks and balances on an expert level to make sure that what the conditions are actually being complied with.
Okay. Are there any other thoughts on the topic? All right. Well, as I said before, I think this kind of question really warrants a formal record request so that all of this thinking can be compiled into one authoritative response, and the town can perhaps even confer with others in official capacities to get the best recommendations put forward in terms of what conditions might be recommended to the board. And again, tying that specifically to the hypothetical grant of the zoning exemption request. So I think that's the crux of really what the witnesses are recommending.
So, Mr. Green, can I just add one thing to my testimony? Is that rendering that you asked for, actually one of our witnesses found that it wasn't just Ann Barrick who had that rendering with the buildings, but you're actually going to get one, and we've already forwarded on to Mr. Pucci, that is in May of 2021. That's actually from Mayflower Wind themselves, showing the building being in a different location than what the proposed station is right now, and that they were in buildings. So it's not only Ann Barrick, it was Mayflower Wind, who I think is just, SouthCoast has just changed its name, and they're still the same player. So they themselves have put a rendering out to us that showed a building where the converter stations were.
I would recommend that when the town responds to that record request, that it just note what you were just describing along with the image.
It will be. Thank you.
At any rate, back to,
Can I get the record request number?
yes,
Mr. Green's record request should be RR-EFSB-29. And I'll just, Mr. I'm sorry, did someone say something?
I tried to talk quietly to the closed door. I apologize.
That's right. The 29, and Mr. Pucci, you're going to be assembling it. So do you understand what Mr. Green wants?
I do totally. Thank you. It's much
Good.
appreciated. Thank you.
Thank you.
Mr. Shea,
Yes, sir.
just a clarification. I have record request 28 as being town to provide what conditions it would want imposed on the company, et cetera. And now I'm hearing, is that 29 now, or I just want to get clarity on the record request?
I thought 28 was a copy of the, I have in my notes, the idyllic version of the project that was proposed by Ann Barr.
That's what I had.
That's correct, Mr. Shea.
Okay,
Who said that's correct? I want to,
I don't believe I used the word idyllic.
no, you didn't. That's my characterization of the testimony.
Mr. Runch, I think what happened was Mr. Shea did not want to override the one he withdrawn earlier. So there's just one blank record request that's 20, I believe.
could I ask the court reporter or Mr. Shea to tell me what was that one that was withdrawn, RR 27?
27, that was when I asked for copies of the actual letters that the children had written to various boards saying that they couldn't sleep.
Thank you. I got it.
With the record's full enough, we don't need to, the testimony was sufficient on that point. So we withdrew that record request, but I didn't want to give another record request the same number. So 28 is a copy of the vision of the project that was referred to as maybe resembling the Sydney Opera House, promoted by Ambaric, and 28 is the proposed conditions.
Thank you.
29 is the proposed conditions. 28 was the Sydney Opera House.
Okay, I am done with my questions.
Okay, Ms. Devakar, you have some follow-up?
Yeah. So following up on Andy's, Mr. Green's line of inquiry, I was wondering if there are boards and commissions which actually get to decide on the many aspects of this project. For example, noise, air emissions, lighting levels, etc. Outside the zoning board. I was wondering if there are other boards. For example, this question is because I heard Mr. Turner mention that,
I'm sorry, Mr. McDonald.
Mr. Turner?
Mr. Turner.
Oh,
What was the question again? I'm sorry.
I heard Mr. Turner mention that the Board of Health can actually go in and make assessments on, lighting, on stormwater, on noise levels, etc. So I was trying to understand, are there other boards or commissions for the town of Somerset that decide on these matters?
Yeah, well, outside of the zoning board, the planning board would make a recommendation for site plan review and plan development hearing, and they could include any of those. If it came down to it, the Board of Health could convene and they could set some conditions. Conservation Commission to a degree.
Okay. So the decision-making points would still be the planning board, the zoning board of appeals, and the Conservation Commission. The rest are, I understand, advisory in function. Is it right?
That last part.
The rest is advisory in function.
Yes.
Yes. So So the standards that apply to the many aspects of the project, for example, noise, light levels, air emission quality, would be standards set by the Zoning Board of Appeals or the Planning Board. Do I get this right?
Nicole McDonald, if I could, I'll just walk you through briefly how the town permitting is set up. Most of these projects, if you have more than one business or a certain level of development, they file
Any industrial.
or in any industrial property, the petitioner files what's called a plan development. That petition for plan development goes to the planning board first. The planning board makes a recommendation to the zoning board, and within that recommendation, the planning board can propose or suggest conditions to the zoning board. The petition then goes to the zoning board. The zoning board conducts its hearing and would issue either an approval or a denial of the plan development. And within that plan development permit approval, the zoning board sets conditions that historically would address dust, noise, truck traffic, hours of operation, lighting, setbacks, anything within our zoning board of appeals to comply with the purpose of the zoning board, which is to protect the health and safety, lessen congestion on the streets. So the zoning board normally in its plan development will address all of these issues following a public hearing. And the zoning board in Somerset is a very strong board. Our chairman is an engineer. We have an attorney. They're very experienced members, and they've reviewed these, similar petitions, and they were the permitting authority for the scrap metal. In addition to the zoning, anything within the wetlands protection would come before the Conservation Commission under a notice of intent. Within the noise bylaw, there is a request for development to also go before the Board of Health. So this type of a project would come before planning and zoning for plan development, conservation for a notice of intent, and the Board of Health for a noise assessment. That would be the permitting route for a project of this character.
That's very helpful. So with each of these agencies, basically what is being checked for are whether the company is actually complying to certain standards, right?
Correct.
Please.
Yes. So within the zoning bylaws, it talks about for the industrial uses, there's language to the effect of saying that dust, fumes, odors be effectively confined to the site, that noise, flashing, vibration not be perceptible beyond the site without instrumentation. And then, so that is how the zoning board has traditionally or historically handled these petitions. The dust standard was the subject of the litigation before Judge Foster. And during the course of that litigation, you can see it in Judge Foster's decision. The town was saying it's a no dust standard, meaning no dust can leave the property. The scrap metal company and the owner of the property was arguing that they should be allowed to have dust up to the EPA limit of 150 micrograms. 150 micrograms leave the site before it becomes actionable and they have to take measures to control the dust. Judge Foster struck the balance to basically say that language in the zoning bylaws boils down to something that's actually very common sense and very easy to enforce, that the dust and odors and fumes shouldn't be affecting the residents. So if the residents have to stay in their homes and close their windows and they can't sit in their backyard, and when they go out, they can experience the dust and taste it, the judge said, if you're at that level, you're not effectively confining it to the site.
Thank you, Ms. McDonald. I have a follow-up to that. So you were mentioning standards against which any proposal is vetted, be it the zoning board, the planning board, or the conservation commission. So I'd like to, if it's okay, I'd like to place a record request to obtain the various standards against which these proposals would be vetted by 1, the zoning board, 2, the planning board, and 3, the conservation commission.
Okay, and that's record request RR-EFSB-30.
Could I suggest respectfully an amendment to include Board of Health to that?
Thank you. I'm sorry for the omission. Yes, that is of interest to us. Thank you.
Thank you very much.
I have a question. I'm wondering, don't we already have the zoning bylaws on the record, probably from the initial filing, Mr. Runge?
Zoning bylaws in the record. I don't know if it was in the initial filing, but it's in the record as a response to an information request, I believe.
So we would already, we would already have those, I believe.
Yeah, so you're right. In the zoning petition itself, I believe that zoning bylaw was part of that package.
Yeah, I think I recall seeing it. Yeah. So maybe the rest, yeah.
I didn't take the zoning bylaw itself as really the issue in the information request. It's more what standards, are applicable to any of these boards and, where they're derived from. So if like the standard that Ms. McDonald just talked about, that's out of a specific provision of the bylaw, zoning bylaw. So I would anticipate, the response to that is going to point out where various standards come from and who would have jurisdiction over them.
Yes, that's what we are expecting. Yeah.
Thank you.
Now, if I have a few record requests to make.
Question.
Okay, for now, I'll just pass on to Mr. Van, and then I'll follow up with some record requests, if that's okay, Mr. Shea.
Yes, I'm sorry, I didn't quite catch it. You'll pass on to whom?
Mr. Van?
Wang, and then after Ms. Wang speaks,
and
you'll do this.
and then I would like to make some record requests, if that's okay.
And I believe those record requests are for the company, not for the town.
That's true.
Yeah, okay. So I want to thank the town witnesses for taking the time today to speak to us. And it's been a long day. I promise I only have a couple questions just to wrap up. I wanted to confirm, I think Ms. Souza had talked about some thoughts about restricting construction. I wanted to know if to your knowledge, the witnesses know about any bylaws or regulations in the town that have restrictions on construction hours related to noise or so on, like hours of noise or construction.
So our noise bylaw does account for all noise.
I'm sorry, are you Miss Souza?
I apologize. Kathleen Souza, yes, I apologize. So our noise bylaw does speak to hours that the noise has to be minimized. So I believe it's 10 p.m.
7 a.m.
10 p.m. to 7 a.m. But due to the proximity to the neighborhood for construction noise, I think it's 65 dB up till
Residential 10, 65 up to 10 p.m.
Yeah.
And 55 from 10 p.m. to 7 a.m.
Thank you. Are there any restrictions on the days of the week?
There is. Sundays and legal holidays.
Thank you. Okay. In Mr. McDonald's testimony, yes, and also today, you had spoken about some possible hypothetical security issue of kids getting into the Brayton Point site. I was wondering if this was an existing issue or if this was just something you had thought could happen.
No, it's an existing issue. I mean, we don't have somebody here today that lived in that neighborhood, and they used to have a game where could they get onto the site and run and touch the big green building before security caught them. So, and just so you know, part of this site is fenced in, but actually the north part of the site, you can just go into the, what we say, the Great Point Energy Building area, and you can openly walk into the whole complex free. There's no fence whatsoever. And yeah, kids are kids. And we are having right now, they're right up the street is an apartment complex that's gonna go in with maybe 15 to 18 apartments, maybe more kids. We were talking about kids at lunch, and there's probably more kids than we even think. We think that there's probably about 40 kids in that neighborhood. And of course, that's a big industrial site. And when you tell somebody don't go in it and you're a kid, what do? We test those boundaries, don't we? And I did when I was a kid, climbing electrical towers, which I probably should have never done, climbing water tanks, crossed the Braga Bridge catwalk from Fall River to Somerset. I mean, so I did it myself, and I shudder to think about what I did, because I probably shouldn't be here right now, but we did it and I made it.
Mr. McDonald,
You have the right to remain silent.
Yeah, exactly. Probably spray painted my name somewhere, so.
thank you, Mr. McDonald, and you are on
Statute of
record.
limitations, yes, statute of limitations is applicable.
Thank you. I had another quick question. In Mr. Pelletier's testimony, he had talked about some studies that were done. Let me just pull it up. Air, underwater soil, and traffic studies done in the past. And I believe, Ms. McDonald, you had maybe mentioned a study as well. I wanted to know what those studies were that Mr. Pelletier and Ms. McDonald were referring to.
So in the last several years, as we had problems with the scrap metal, as they were digging, to lay out areas that they're going to dredge. We've had traffic studies for Prismian, and prior to that for scrap metal and for other issues. I'm not referring to any one particular study. I'm just referring to piles and piles of studies that I'm just a citizen, but I tend to read all this stuff. So I couldn't point you to any particular one, unfortunately. But there are a lot of studies that have been done over the last few years. But my point was that things have changed, and especially with traffic. I think I mentioned that Route 79 in Fall River has been completely redone. And so now we're seeing a lot of people who used to drive along the Taunton River by the toward the Battleship, Massachusetts.
I'm sorry, George, what?
The Battleship, Massachusetts in Fall River. They now tend to take the Veterans Memorial Bridge and cut through Somerset. A lot of them going up Route 103 and adding to the traffic that's there since our last study. So I quite often go through there and all the traffic is backed up. And that's very recent since they started doing this work in Fall River. So my point is that a lot of this data, this old data, which doesn't look that old, is no longer applicable. I know that there have been a lot of references to, I apologize for not looking at the owl. I keep looking at the screen over here, but not that it makes a difference. But there's a lot of references to contaminated areas on the Brayton Point LLC property. And the other thing I alluded to was that there's been so much movement of material on that site that I don't believe has been documented. There are cooling pools and ponds that have been filled in with material from the bricks from the smokestacks coming down, contaminated soils being bulldozed to level things out. The area is much leveler than it used to be, but that was accomplished by moving a lot of material around. So if you're looking at old maps where the Brayton Point Power Plant has clearly marked, okay, this is a hazardous area, this is and I'm not sure of all the terminologies, but this is an oil spill area, all those areas are marked out very clearly on old maps. But my contention is that that's no longer accurate, that some of those materials have been moved, that areas have been filled in, specifically the area where it appears to me, if I look at Google Maps, look at the satellite view, and then I look at the SouthCoast wind diagram of where they want to put their building. I mentioned this several times, but I don't. It's in my. I think it's in my testimony. That I believe that the area that they're planning to build on had two lined pools. Now I don't know what the pool's originally use was. I do know that they're filled in. I don't know if they're filled in with contaminated material. But they're lined pools, and I don't know if the material they filled them in with has punctured those linings. I don't know if CDC's intention is to completely remove those pools. I don't believe it is, but it doesn't seem like an appropriate base for for a high voltage converter station. So those are the kinds of things I was alluding to. That these some of these soil tests, some of these traffic data that may have been taken all over the years. And I know in the days of the power plant was very meticulously kept, that a lot of that information might not be accurate any longer. So my assumption is that it's time for some real testing, some new testing in any area that's going to be disturbed, whether it's area where the drilling is going to be done, or whether it's the area where the construction is going to be done, where the where the buildings are going to end up. So that I think hopefully that answers your question. That was my contention.
Yes, thank you, Mr. Pelletier. Just one question.
This is Paul Healy. Can I just add a little bit?
Sure. If Mr. Healy, to the extent that anything you say is in your testimony, I don't need to hear that again, but if you're adding something new.
I am adding something new. This is Paul Healy. Just to let you know, I've done a lot of paper review at the Mass DEP waste site reportable release the area, specifically the AUL area 169, and there's a lot of graphic material in there talking about the changes that have occurred over time that I think is useful in describing what's at least below some of the areas that are currently there.
Thank you, Mr. Healy. Mr. Pelletier, just one last question on the traffic. You had stated in your testimony that Route 79 was closed. Do you have an idea of how long that might persist?
It's not actually closed, it's reconfigured. It used to be a multi-lane highway, and well, I guess, see, it's Route 79 is technically, well, there were several roads there, and there was a main highway there. So what they've done is remove them all and have everybody going through one of the side roads. So the side road that everybody's going on was referred to as Route 6, but I'm not sure if they're now referring to it as Route 79. But what used to be Route 79 is now just completely bulldozed over. It's gone and never to return. But they're reconfiguring the whole area, so it's not. It's not like it's a temporary change. It's a complete reconfiguring of probably two to three roads and maybe 5 lanes of traffic.
I appreciate that. So if I'm understanding right, it's your expectation that the current road conditions will remain for the foreseeable future. Is that correct?
Correct.
Thank you. Okay, so final question, just for, because you're all residences, living close by, I wanted to just get a feel of how easy has it, how sufficient has it been to be able to communicate with the company about issues, or how has the company's outreach been for the community?
They've been horrible.
No,
Which company?
I think he's referring to SouthCoast.
Oh, SouthCoast?
If we could,
Yeah, which company?
SouthCoast Wind.
Okay. I've met with SouthCoast Wind several times. They're great people. I've talked to Kelsey and Kelly, right? Yeah, Kelly, Kelsey, and I also spoke with an Eric Frazier, who was a great source of information. So yeah, no, SouthCoast Wind has been great. I've had very good discussions with them. Reality is yet to be seen, but but they've been great people. They've answered my questions. Is that your question?
Yeah, is it?
Wayne, you just went out on my end. I don't know if.
Yeah, you have no, you're muted or something.
Wayne, we can't hear you.
Yeah, we can't.
Can you hear me now?
Yes.
Yes.
Okay, so has it been the rest of the witnesses' experience, more or less? Would you characterize it that way, that the company's been approachable and such?
So Nicole McDonald, I think the company has portrayed the willingness to host a meeting and field questions. The concern is that the answers don't really provide the substance. And, speaking on behalf of myself, and I think this represents the collective, we're not looking to be just placated and told everything will be okay. We're more concerned with the reality, and a lot of questions are asked at the public meetings, and the response is, well, we haven't selected the contractor. We're at 30% design. We'll get back to you. That's our concern. So very friendly, very nice, but we're looking for the actual facts and the reality that we're going to be looking at.
Thank you, Mr. Pelletier and Mr. Mick.
Just Mr. Pelletier again. Just quickly, I 100% agree with Mrs. McDonald that yes, my interactions with them have been great, but a lot of the answers are exactly what Mrs. McDonald said, that we don't know what the method is going to be to do this particular thing yet, because we don't have the we don't have the contractor chosen yet, and or timing, the same thing. We don't have the timing yet because we don't have the contractor. And I think I mentioned some of this stuff earlier in my testimony, but I agree with Mrs. McDonald that the people that have that I've interfaced with have been real good about answering questions with the answers that they have. But there are a lot of answers that they don't have because they're so early in the process.
And this is Patrick Donald, and I just want to say that I concur with Nicole and Peter about that the presentations have been okay. They're not very in-depth. But I would say that Kelsey, Kelly, and Tim, what I'm really impressed about is their age and their ability to communicate with people of all ages at their age. I look at them as kids, and they're doing a great job. That the company should be proud of them, and they're out there and they're doing what they're supposed to do for their company. They can only give the information that their company allows, and it's been a surface presentation. But I'd say, as far as them being courteous, even when I'm rough with them in a meeting, they are composed, polite, courteous, and they try to answer the question to the best of their ability with the constraints that their companies put on them, but they're very nice people.
Kathleen Souza and I will agree with everything that was just said, and Kelsey had reached out to me early on, and just with notification to make sure, if somebody's going around the neighborhood, we know that it's SouthCoast Wind going around the neighborhood. And I agree, extremely, extremely nice people, very friendly, very well spoken. But I agree with Pat, they're giving the answers that their company gives them to answer, where we're, like Nicole said, looking for the harder questions that are tough for them to answer with only 30% completion. And we are the ones that are going to be living side by side every day. So that's all I have.
Appreciate your answers. I'm all set for the town witnesses. Does anyone else have questions?
I think Ms. Divakar had some record requests you wanted to propound.
But I think that would be for the company. So maybe.
Okay.
Yeah.
Are there any other questions for the town's witnesses? Mr. Pucci, do you want to do any redirect?
No, thank you.
Okay.
Chairman Shea, we just wanted to thank the board for your time today, and your efforts. We all greatly appreciate it.
Well, thank you for coming, and thank you for your very, very complete answers that you've given. I appreciate it. We all appreciate it.
Thank you.
Thank you.
All right, now we'll go with Ms. Divakar. If you would like to, if you have record requests to make with the company, it'd be a good time.
Are we allowed to?
Can we say goodbye to the town witnesses?
Just a minute. I'm sorry. I've got several people talking. What?
I'm sorry, Mr. Brock. It's Attorney Pucci. I was wondering if we could say goodbye to the town witnesses, or do we need them?
No, I don't think we need them. Goodbye and thank you.
Thank
Bye,
you.
everybody.
Bye.
Okay, I'll turn the floor over to Ms. Divakar.
Hello, can you hear me all right?
Yes.
Okay, during our earlier discussions on wellhead protection areas, water supply sources, etc., I suppose Mr. Durand and Ms. Smith participated in it. We referred to a couple of maps, if I remember right. They showed the project site with reference to the wellhead protection areas and the tributaries that feed the water supply reservoir for Fall River.
I'm sorry, that feed the water supply what for Fall River?
Reservoir for Fall River.
Thank you.
Now, the siting board would like these maps submitted, and if you could include all the relevant distances from the project site property lines.
So may I just ask clarification, Eric Runge for the company. Where did you see these maps, or who identified them? I'm just trying to identify where these maps are.
We discussed these maps, I suppose, in the hearings, in the third day of hearings, and it was Mr. Durand that helped produce or share these maps on the screen.
Okay, so it's something he shared on the screen, Mr. Durand.
That's correct. We had, there were some questions about wellhead protection areas, aquifers, and we had some maps we had generated for the analysis and also for the EIR and FEIR, but some of the mapping we had prepared kind of during Smith's requests. So we have that, and we can provide that.
Okay,
Thank you.
as long as you know what you're looking for, Jamie, thank you.
Yep.
Thank you, Mr. Durand. Now, the second record request. So do we have a number to that record request yet?
That would be record request RR-EFSB-31.
Thank you. Now, the second one, While replying to Mr. Pucci with regard to site assessments and addressing his concerns with the activity use limitation cells on the site, I recall the company mentioning 2 studies that were completed and available. One that began in 2021 and the other, I believe, was the ASTM phase 2 study, which began in 2022. So the siting board would like to have copies of these site assessments. And if the company could clearly identify the names of these assessments once more.
I'm going to look to Kathleen Freeman if she can tell me whether she knows which assessments are being asked for here first.
Yes, Kathleen Freeman. I believe the 2 assessments you are referencing are confidential assessments that were prepared on behalf of the company. One is the ASTM phase 1 prepared by Power Engineers, and the second was an ASTM phase 2 prepared by GZA Geoenvironmental, and they were prepared for our council to advise us on our liability as an innocent tenant under and to establish that status. So they are confidential documents.
It sounds like they're more than confidential. Eric Runge speaking for the company. It sounds like they may be privileged and confidential documents. I have not seen them yet, so that's what I think they are.
So I understand that we cannot be processing this record request, right? Because these wouldn't be available.
If they're privileged and confidential and they sound like they were prepared at the request of counsel to assess liability, then they would be covered by the privilege and we would not produce them.
Excuse me, this is Attorney Pucci.
Yes, sir.
You know what, I would request in follow-up that record request go through. And then if the company decides that they're privileged under any basis, that there be an actual response, you know, with the information that is not privileged and confidential and the grounds for any confidentiality claim. So I would think it would be a very bad idea to just withdraw the request. I think you need further responsive information in response to that request.
Mr. Runge, would you object to, a response, even if the response is just, this is privileged and confidential for the following reasons?
No, I wouldn't object to that. We can put that on the record.
And then if there's any information that's not privileged and not confidential, and I'm not saying there will be, but if there is such, then you could provide that information.
If it's not privileged and confidential, but is nevertheless confidential, we could file some of that redacted with a motion for protective treatment.
Okay, that makes sense. So that should be record request RR-EFSB-32.
Thank you, Mr. Chair. Jason. Yeah. Another information I would request for is information on the current sources of water supply for Brayton Point site.
Eric Runge for the company, just to clarify it, you're asking that of the company rather than the town?
So, so good that you asked me this question. So I'm trying to understand the water supply sources for both the Brayton Point site and the town of Somerset. I'm not sure if they are the same. So for now, the question is to the company to identify the sources of water supply for the Brayton Point site. And if the company, if the town could help do the same for its jurisdiction, where does the town of Somerset get its water supply from? That information will help as well.
Do you want to do that as one or two information requests?
2 sounds good.
2, okay.
Yeah.
Okay, so the current sources of water supply for the Brayton Pond site would be Brayton Point site, excuse me, would be EFSB RR-EFSB-33, and the current sources of water for the supplied for the town of Somerset would be RR-EFSB-34.
And just to be clear on that last one, Eric Runge speaking, that is for the town of Somerset to respond to, correct?
That's right, yes.
Thank you.
So one more question to go. So we had a discussion on the choice of 100 milligrams per liter as the desirable TSS concentration limit.
I'm sorry, as the what?
As the desirable TSS concentration limit.
BSS as in boy.
T as in Timothy, S as in Sam, S as in Sam.
Thank you.
Now, I remember Mr. Mendelson was part of that discussion. And if I remember right, well, I wouldn't, let me just mention that. So I would like, I know that the company said that it would get back after verifying what the significance of this particular limit was. So since we've had no, response in that regard, I would like to submit this as a record request.
That is
May I just ask a question of Ms. Freeman, who's here? Do you, Ms. Freeman, you look like you might have some follow-up on that. Can I just ask you?
Yes, Kathleen Freeman. Yes, we have a record request for explaining the significance of the 100 milligram per liter TSS biological indicator, and we have responded to that record request. I believe it's filed today.
Okay, in that case, it's a mistake on my part. Thank you. Thank you for the information. Yeah. So that's all I've got.
Could I just follow up on one of the record requests that Ms. Divakar was asking for, just to get a little more clarification?
Sure, go ahead, Mr. Green.
Yeah, I'd like to address the phase 1 and phase 2 ASTM studies that she was asking for and I don't remember the record request number.
That'd be 32.
32. Mr. Runge was mentioning that this is a privileged and confidential document, and the company might very well not produce it in response to the record request. I wanted to explore that just a little bit before we get the same information in writing. Having worked with both of these types of documents and some of the work that I did prior to the siting board, I can just personally tell you they're very useful documents. They're very informative on the history of a property as well as what the current conditions are, and quite relevant to a lot of the information that has been the subject of discovery and testimony in this proceeding. So I think there's great interest in the documents, and I want to understand a little bit more clearly why the company thinks providing these documents would not be possible given confidentiality considerations or other privilege, because you don't own the site right now, so whatever contaminants are in the soil, groundwater were not deposited by SouthCoast Wind, are not your company's liability, which is usually where the reluctance comes from to provide these types of documents. So I don't understand. So I guess I want to just hear a little bit more, fully where the concern comes from that disclosing your research on the property could present a confidentiality issue.
I can start, and then perhaps.
I'm sorry, who is this?
This is Eric Runge for the
thank you.
And so I'll start, and then Ms. Freeman can follow up if she cares to. But I think what I heard, and I was pretty careful to say that I hadn't yet discussed this with Ms. Freeman, and so I hadn't made a determination if this is material that is privileged and confidential necessarily. But the concern that I heard was that the studies were done and were used to explore with counsel innocent tenant liability issues, and therefore there was legal analysis related to liability for the company associated with these assessments. So I think that's the basis that we're talking about.
Yeah, I understand that the notion of an innocent tenant, which is, again, you lease or buy a property and the company had no involvement in the prior use of the property and potential liability for prior contamination. And you know, my experience with these studies is it documents what the current conditions are to ward off claims of responsibility that are not attributable to the company.
Mm-hmm.
So, you know, from that standpoint, it's kind of a baseline measurement that you go forward from. And it is a very useful baseline in terms of understanding the condition of the property and what provisions may be needed to construct on it, given what's known about it. And that's why it would be useful to the board, and I imagine interveners as well. So, again, I can understand the reluctance when it's the site owner who has the history, may have operated the property and had some responsibility for its present condition, but that does not apply to South Coast Wind, as far as I know. So, I think we want to be well informed as to what the real concern is about the confidentiality surrounding these studies.
Right, and that's why we were going to take that under advisement, look at the studies, consult with the client, and make a determination based on that.
One thing that we could do is we could ask that the response to RR-EFSB-32, the ASTM documents, Mr. Runge, if you don't, if you're not going to produce them, we'd like a fuller response than simply these are privileged and confidential, but rather something almost in the nature of a legal brief, that under the law of confidentiality, these are documents prepared in anticipation of litigation or whatever they are, and citations to the relevant statutes or case law. Do you think that you could do that?
I think that's quite possible, yes.
Right, and then we'll see where we go from there.
Mr. Shea, I know we have 10 minutes. Can I ask one or two questions?
Of course.
I really appreciate the company witnesses' patience for staying on so long. I expected to get to these questions much earlier today, but thank you for waiting. So earlier in the hearings, I had questions about community notifications, and Ms. Freeman has started to answer. And I think the FEIR also provides examples of meetings and such that the company has conducted. What I'm looking for in addition to that, and it sounds like, and also we heard from the residents is about the nature of those meetings and outreach and presentations. What I'm looking for in addition to that is examples of outreach materials such that we sort of have a feel of what that looks like. Do you think you could provide that, or if that's on the record already?
This is Kelsey. We would be happy to provide that. We have sent things like physical mailers to different communities that we could provide. Many of our virtual presentations are recorded and on our website, so we can send you links and also provide PDF copies of presentations that we presented, posters that we have available at our drop-in session at the public library. So if it makes sense, I guess, I could put together a little package of some of these materials and submit it as an information request.
I'd appreciate that. And to not make, the record, which is already really, extensive, too much more voluminous, maybe just choose at your discretion, like representative material. That makes sense.
Yeah, that's no problem.
Eric Runge for the company. Is that a record request that I hear? And what's the
Should be, yes, thank you.
Okay, that would be record request RR-EFSB 35.
Thank you. And the other question that I had, that was punted for today was, the analysis from the company at 5-43, the company talks about a stakeholder engagement plan. Does that sound familiar?
Yep,
I'm sorry, who said that?
Kelsey Perry for the company.
Thank you. So, it sort of, it describes, the company's plan to carry out the stakeholder engagement plan. I wanted to get more of an idea of, has this plan been implemented yet, or is this something that's going to happen in the future?
This is Kelsey for the company. This plan has been implemented. We consider it to be a live document in our external affairs department. So I believe we first created the plan back in 2020. But there have been multiple versions of that plan since then. But it is, a live document. We are following that plan actively because it's our communications plan during the permitting development phase of the project. And as mentioned during other questions during this hearing, we will have a communications plan for construction that will be developed.
Thank you. And from what I understand from the text in that analysis was that you expected to gather some information from external stakeholders through that plan. Could you briefly describe what type of information you've collected?
Sure, no problem. So typically, we usually gather the most information at our community events. We develop, robust Q&A sheets based on the questions that we hear at these events. So, for the virtual events, it's pretty easy because all of the questions are typed in and we're able to record them. During our in-person events, we will take notes and then develop Q&A responses. We also have a state tracker system. It's a software system that we pay for where we're able to log stakeholder interactions and take notes for when we have, individual phone calls and things like that.
Thank you. Finally, would the company expect stakeholders, which I assume include residences and butters to the site? Does that include them?
Yes, definitely. They're one of our most important stakeholders, I would say.
Thank you. Will the company expect, as the project design for progresses further along and as the stakeholders get more involved, that they would have specific requests as to mitigation related to their properties, or is that not something that you collect through these plans?
Related to their personal properties, you mean?
Yes, if an abutter were to say, could you put in mitigation at my property such that the noise actually is attenuated further?
Yeah, and this would be during the construction process or prior to?
Whenever.
Yeah, so I think, for right now, as I mentioned, we've kind of been actively collecting feedback from residents in the town, and we try to incorporate the feedback as we're, designing the project. Kelly Smith mentioned, and I'm pretty sure went into detail on the example of us, meeting with the town, getting a better understanding of the noise control bylaw.
I'm sorry, getting a better understanding of what?
The noise control bylaw and working to meet that. So right now it's more of an ad hoc way of us listening and incorporating that feedback where feasible. Once we're in the actual construction period, As I mentioned, we'll have a construction communications plan, which I anticipate will have a more, concrete grievance mechanism for if folks have, any issues during construction, they'll be able to reach out to us and we'll be able to resolve those issues quickly with our contractors. And during construction, we'll also have a construction schedule webpage where residents can reach out to us through there, and a 24/7 hotline number for folks to inquire about construction.
Thank you, Ms. Perry. Last question, just at the top of mind. This is probably Ms. Freeman, probably you can answer this. Is it on the record? Do we have on the record the company's intended construction hours and construction days in the week?
Kathleen Freeman, yes, that is in our NEPA filings and also in our analysis.
Off the top of your head, could you tell me the hours and days?
It varies depending upon the operations. I think, Tim, do you want to speak to HED? We are actually, our FEIR that was filed on Friday has refined.
I have it.
Oh, you have it, perfect, okay.
This is Kelsey. I think in our FEIR final environmental impact report that you all are going to review, we did address this and stated that we'll develop construction hours in accordance with the local Somerset noise ordinance and municipal regulated construction hours to the extent practical and in accordance with the town of Somerset. In some instances, in particular during HDD that Tim can talk about, we might have to perform construction during.
I'm sorry, we might have to what?
Perform construction during the nighttime or continuous construction, and we will file permit applications with the town of Somerset if that's needed.
I appreciate that. I'll review that and possibly have questions on our FEIR day. I'm all set for today, Mr. Shea.
Okay, we have, right, well, we're still on the record. We have one more day of hearing scheduled for August 7th. And I believe that's when we're going to go over the FEIR information. I'd like to ask the other people from the EFSB online, do we want to ask for the town administrator to be available during that time also?
I think we would appreciate that.
Okay.
I agree.
Yeah.
Joan?
I agree.
Okay. All right. Then, Mr. Pucci, would it be possible to have the town administrator there on the 7th?
Definitely possible, probable. The only thing I need to do is I need to check with him that it's not his 25th wedding anniversary or something, or he's in France or whatever on that particular day. I just haven't confirmed his availability. But when we get off of this session, I will call him on his cell phone and make sure he's available on the 7th. Can I ask respectfully if I can't produce him somehow on the 7th, can I produce him another day, even if we have that day on the 7th? I'm just trying to figure out a way if he happens to be out of the country or something unanticipated on August 7th.
Right, I understand. If he's out of the country, we're not going to expect to see him. If he's also, you can only produce witnesses who are available. Are
we anticipating meeting him at 10 a.m. or?
That would be nice.
Okay.
If he's not available on the 7th, why don't you send us all, everybody in the service list, emails about the dates that he might be available?
Much appreciated. I will do that.
All right. And then I think, Mr. Runge, did you request from me a new hearing schedule?
Well, I think we wanted to just update it now to reflect the August 7th date, but I did ask at some point in the not too distant future, I'd like to get a sense of when initial brief and reply briefs would be due.
Okay.
So that we can plan accordingly.
All right, very good. I'll take that, we'll take that under advisement.
Could I just say, Mr. Shea, just, our general rule is,
Yes,
and we might adjust it here, but our general rule is 3 weeks initial. After the last record request, 2 weeks reply. That's our general rule for general planning purposes.
Thank you.
and it's 3 weeks after the last record request is received. The last record request response is received.
And when you count back, do you count back like whatever the deadline is for responding to the record request? And then you calculate out 3 weeks?
Right, but if there are record requests that can't be answered in time, then that complicates matters.
Yeah.
You know, because we do want to have the briefing on a full record, a complete record. So it's the record, it's the due date. Yes, it's very important, but the date it's actually produced is also important. If something couldn't be, if a record request can't be answered, we probably won't schedule the initial, we won't issue a briefing schedule until the record request is actually answered.
Well, Mr. Shea, if I might just follow up on that particular point. I know that there were a couple of record requests for us that had like an indeterminate due date. It was like when it was available. Some of those, you know, could be, one is only maybe a month out or 3 weeks out, but I thought another one was, you know, when you have an executed agreement.
Execute ground lease, yeah, I remember that.
Like that can't be used as the determinant for when briefs would be due, right?
Well, that's a good point. Yes, there are some things that are record requests to which you cannot respond just pursuant to matters that are not within your control, such as the request for an executed ground lease. So those wouldn't be, those generally are not included in our briefing schedule. But we can talk about the briefing schedule when we meet next on August 7th, and that's our. Joan has given you our general rule, what we do. So if it was August 7th, and if all record requests are issued and responded to by August 14th, then we would say ask for initial briefs 3 weeks after August 14th and 2 weeks after that for reply. But I don't want to set that in stone right now until we see what's out there and any complications that may arise.
Okay, thank you.
Thank you. All right. Well, again, thank you all to the witnesses. Thank you for being so well prepared. Very much appreciate it. And I will see you all on the 7th. Thank you and good night.
Bye-bye.
Thank you.
Okay.